Yes, sir. Huh.
Division bench, item 1. For delivery of order.
The appeal is allowed. The appellant is given the benefit of doubt and his conviction and sentence is set aside. He shall be released forthwith if not wanted in any other case. Before releasing the applicant, an undertaking shall be obtained by the Superintendent District Jail, Sivsagar, where he is currently lodged to the effect that he would surrender as and when called upon to do so by virtue of any appellate order that may be passed against the judgment and order. The legal aid counsel shall be entitled to her usual honorarium. Thank you, sister. Yes.
Hello, item number 45, bail matter. Whether your lawsuit will take up or not. If your lawsuit takes up, then fresh matter one.
$45.
Yes.
We'll try to take up.
Madam,
We'll try to take up.
then only at 2, madam.
Hmm?
At 2. At 2.
At 2. Okay. If it is there, no.
They remain in. Yes.
Okay. Okay.
May I have your lordship's kind leave to mention, my lord, the last matter in the list, your lordships. Item number 56. Lord, there is some urgency in the matter. This matter pertains to recovery of excess amount paid to an employee of a PSU, my lord, and we are suffering an interim order, restraining us to not to recover the same, my lord. And now, my lord, this employee is going to retire in this month itself, my lord. Therefore, my lord, if this matter can be heard, my lord, out of turn at 2 p.m. or any time as your lordship feels, my lord.
Hearing, you'll have to wait till we have.
But in that even only one observation I will beseech from your lordship, my other side is also there. Since there is an interim order, my lord, the superannuation.
No, this is the motion matter.
My lord, this is a motion matter, but my lord, it is ready for hearing, my lord. All pleadings have
No,
been
no,
done.
hearing we can't say because we won't
Lord,
be able to assure
Then,
you
my lord,
right
I will
now.
beseech your lordship to only observe one thing, my lord, that the pendency of the payment of superannuation benefit will be subject to abide by the result of the
Let us see
petition.
when the matter is called. Right now we don't have that matter on board.
I am
Wait for
also
your
coming
turn.
from, my lord, outside, but so if in that
Wait
event,
for your turn. Let the matter be called. It's a motion matter. It will be called.
give you.
Item number.
Yes.
My pleasure, Lordship. My lord, I beg to mention item number 39, my lord. We have filed an affidavit and I may be permitted to requisition, my lord.
Yes.
And that apart, my lord, item number 3 be taken up together with 60 and 61, my.
50, 51.
No, my lord, 60, 61 and item 3 be taken up together.
Okay. I beg to mention for withdrawal on the petition. Okay.
May I please your lordship? Lordship, I beg to mention for listing of a writ petition, lordship, for Friday, lordship, matters pertaining to this motion matter, lordship.
Motion, you get it tomorrow. Get it today.
Tomorrow, lordship. Lordship.
May
Deeply obliged.
I please, with the consent of others, I beg to mention item number 55, lordship. In this case, we are appealing for the respondent 1 to 6, lordship. We are led by learned senior counsel MK Suru, lordship. He has some personal difficulty today, lordship. I have after vacation.
Okay. You have informed Mr. Kyal?
Yes, I'm from petition.
Okay, books as represented on the prayer made by Mr. A. Kalitas. Counsel for the respondent number 7 to 10. Matter stands adjourned today, just after ensuing summer vacation on a date to be fixed by the office.
Lordship, another prayer, Lordship, in respect to item number 54, Lordship, as per Lordship direction, Lordship, we have filed an affidavit towards completion of dusty service on Monday. Lordship, I call for that.
May I please, Lordship? Lordship, item number 28. I received an affidavit in opposition yesterday. So I need some more time to file the affidavit in reply.
Item number?
28.
Okay, both sides are represented. List after the ensuing summer vacation, so as to enable the petitioner to file affidavit in opposition in the matter. Affidavit in reply in the matter.
May I please, your Lordship. Lordship, I beg to mention for listing for first fresh motion, Lordship. I filed it on 21/6, Lordship, but yet to be listed, Lordship.
Mr.
Obliged, Lordship.
May I pray for the listing of a motion matter, my lord, tomorrow, my lord.
You can.
May I please, your Lordship. Lordship, I beg to mention for urgent listing of a writ petition. Lordship, the matter relating to handing over charges to a development committee.
After vacation,
Lordship, it's an urgent.
you had a lot of time. Why did you wait for last week? Last week, you have urgency only in the last week for these matters. All this time you were sleeping. Then you know our difficulties. You know the difficulty of the court of the last day. Then
Yes,
how do you make a prayer?
Lordship, item number 26. In item number 26, Lordship, one IA has been filed. 26, Lordship.
Yes.
One IA has been filed. I am allowed to call for that IA, Lordship.
May I please, your Lordship. I beg to mention for a listing over tomorrow for motion, Lordship. New request.
May it please the Lordship. May it please the Lordship. I beg to mention item number 25, my lord. My lord, we have been led by P.N. Goswami, my lord. He's going through bereavement, my lord.
Hmm?
He's been going through bereavement. Item number 25.
Yes. Okay.
My lord, maybe listed after the summer vacation. And on or any date, my lord may fix.
Okay. Who is in bereavement?
My lord, P.N. Goswami, man.
Oh, acha. Okay. Yes. You have informed the petitioner?
Yes, we have taken the consent.
With consent of the other side, Mr. S.P. Sharma, there is standing counsel for the APDC, prays for adjournment. Prayer is allowed. List after the ensuing summer vacation in the motion column.
May it please Lordship, I beg to mention for listing of petition for motion on Friday,
Friday, no.
tomorrow, my lord.
Get it tomorrow.
Okay.
Not on Friday.
Another prayer is that I have filed one IA in regard to item number 10. Kindly call for the. Okay.
May please, your Lordship, I beg to mention for listing of a fresh motion, Lordship, tomorrow if possible. I'm obliged, Lordship.
May I please, your Lordship. Lordship, I beg to mention an item for listing, Lordship. Yesterday, Lordship, for Friday, Lordship.
Tomorrow, make it tomorrow. Either
Obliged,
today or tomorrow, not Friday.
Obliged.
Yeah, I feel about it. It's for motion of the content matter, although listed earlier also.
Not on Friday.
My lord, I beg to mention item number 12. This matter make
12.
This matter may come after vacation. Mrs. S. Bryce has some medical difficulty.
Pardon me?
Yes.
Can you repeat again?
Mrs. S. Bryce has some medical difficulty. Item number 12.
List after ensuing summer vacation. As paid for by land counsel for the petitioner. Yes.
Lordship, I have a prayer for listing of read petitions.
What
For
stage?
listing of read petition, my lord.
What stage?
That is the motion stage. Matter pertains to the transfer.
Make it tomorrow.
Masa.
May I please, your Lordship? I beg to mention item number 40, Lordship, 40 Lordship. Matter will Lordship kindly adjourn, Lordship.
Okay.
As you have some.
List after ensuing summer vacation as paid for by land counsel for the petitioner. 40.
40 Lordship.
Okay.
Deeply obliged, Lordship.
Daily list item 1 for motion.
Yes, item 1. Just after answering some occasion as there is no representation from the petition.
Item 2.
No representation from the petitioner or angel justice matter stands at front. Just after answering some occasion.
Item 3 with item 60 and 61.
You have filed appeal? No.
My lord, we have filed an appeal, my lord. The order outcome has not been given to us, my lord, which is the subject matter of item number, my lord. 60. Yeah, my lord, basically I have
When did you file an appeal?
appeal I have filed, my lord. 2/4/24, my lord.
Where is that?
Lordship will
Page.
see in this petition at page plus annexure. 210, my lord. Or 211, sorry. Item 3.
Yes, what are your instructions?
Lordship,
Why
yes,
appeal are not being taken up?
Lordship, last occasion, your Lordship had directed the personal appearance of the officials. She has come, Lordship.
Yes.
No, I'm representing legal cell of Water Resource Department.
Oh, yes.
Item 61, that is order is there, my lord. Copy to the.
You must be aware why we have called you.
Yes, sir.
Why did you give incomplete instructions to your learned counsel?
So at that moment,
Not only they face an embarrassment, but even we are disturbed by it. That means you intended that the court would pass adverse orders against the petitioner by withholding material facts.
it's an unintentional mistake from our parts.
No, but when you give instructions, why did you conceal one document? Not that when you are sending instructions to your counsel, we are so dependent on the counsel for the treasury that at times we were inclined to dismiss that day because of that lack of that instructions we were inclined to dismiss the writ petition. That means it was a designed intention not to disclose all the material facts. This is a practice we deprecate. We are not supposed to play with the court. At least I consider this to be a temple of justice. If you mislead the court by withholding documents,
So
how could you give it? Why do you give instructions to your counsel without half-heartedly, without knowing the facts completely?
So we provided the document, but somehow that document left.
Oh, please don't do it. We'll take an exception to it. We will record our warning to you. Don't give incomplete instructions. We are really disturbed by it. If you don't believe the state, then whom should a citizen believe? You behave worse than a private litigant. So if private litigants do some mischief, why should we take an exception when the government itself is authority who's playing mischief with the court? You're not supposed to do that. If you are incompetent, please don't be in the illegal cell. Nobody is forcing you to be there. But once you are in the legal cell, you must take responsibility of giving appropriate instructions to your counsel. On that day, we put the petitioner to warning that we will be dismissing it and will be dismissing it with cost. Only thereafter, when the counsel of the petitioner insisted that I should hear him for a moment, then we understood that this is all, you have concealed your instructions. So please write a name and give it.
I have
In this item,
Item 3, my lord.
item 3, we are issuing notice.
My lord, there, my lord, I got some interim prayer also, my lord, because my
What is
lord,
the interim
the
prayer?
very person who is the presenting officer, he himself conducted the entire inquiry, my lord.
No, that's okay. But once we have filed an appeal, we will direct the appellate authority to dispose it off.
My lord, the appellate, my lord, the
Okay.
subsequent filed, I have filed.
May I say,
That, my lord, item 60 will do. Here, my lord, basically, I have challenged only, my lord, departmental proceeding. It has vitiated, my lord.
No, we won't entertain that. You'll have to, once the appeal is there, the appellate authority will decide it. We can't allow two
My
parallel
lord,
proceedings.
my lord, what will do, my lord, at this moment, my lord, item number 3, my lord, notice may be issued as well as notice on interim prayer also.
We'll issue that. That's what we are doing.
Lordship, may I submit, Lordship? The appeal has already been disposed of, Lordship, that about that petitioner is also aware, Lordship. This is
Lordship, kindly see the, my lord, e-filing number, my lord. It is made backdated. E-filing, my lord, last communication was E10. I got the document. It is how it is come manually, my lord. There
Those
has
things-
to be
those
e-filing.
things we don't know.
So e-filing. Down, now. What are e-filing? E-filing last 10 to what? And we have not been served a
This
copy.
is no order at all.
Lordship.
This is no order at all.
Lordship, kindly permit me, my lord, for a moment, my lord. I'll show, my lord, how the file is moving, my lord. Last number, my lord, E-file, my lord. This is most probably, my lord, backdated. On the spot, it is being made.
Today at motion
My
stage,
lord, my lord, my lord.
I'm not
for your-
examining the pure
No, my
book and
lord,
then
for your
then
lordship,
tell.
my lord, I have to bring the notice of your lordship only.
No, that's okay. We can't.
And I have not been served with the copy also.
We'll direct you to provide that. Be provided. You give this in fact if you have not been provided. This is what date? This was
1st of June, Lordship.
1st of June.
Lordship.
Oh, my God, last 10 weeks to communicate for like
But Mr. J.I. Parvian and counsel for the petitioner and Mr. Aram Das, Learned Standing Counsel for the Water Resource Department.
yeah.
First of the Learned Standing Counsel for the Water Resource Department has produced a copy of letter dated 1/6/2024, by which the petitioner was informed about the dismissal of his. No, that is. What is the language? His appeal will not be.
Appeal.
What is the last line? His appeal will not be.
So your appeal petition cannot be considered.
indicating, informing the petitioner that his appeal petition cannot be considered. Stop. Only a copy of this order is provided to the learned counsel for the petitioner. Stop. Province of Justice, the matter stands adjourned today. Let's start our ensuing vacation in the motion column. We are returning to this. We are adjourning this matter. You take instructions.
All three.
No, this first matter, item 3. Now this is item 60.
My lord, item 60 is item 60, my lord. It is the prayer was made, my lord. Lordship, kindly have a look at page 60. Silent, firstly silent. Outcome of the appeal, my lord, though they have not submitted the copy on 4.2, page 29 be seen, my lord. What is the prayer, my lord?
This is a prayer which can't be entertained.
My lord, we have to, my lord, now, my lord, copy has been given. We have to amend this petition. Or lordship can give, my lord, item number 60, my lord, instead of amendment, my lord, lordship give me liberty to file a fresh annexing the that document.
Okay.
That can be.
Only upon instructions, Mr. J.I. Bovimil and counsel for the petitioner seeks to withdraw this petition and to, in view of the subsequent development of not entertaining the appeal of the petitioner by order dated, by a communication dated, sorry, as informed by communication dated 1/6/2024. Mr. Haran Das, learned counsel for the Water Resource Department is present. Next paragraph. Pursuant to order dated 21/6/2024, Mrs. So-and-so, a law officer of the Water Resource Department is present.
How can we say?
She, the expresses regret for inadvertence for which the relevant communication was not provided to their understanding counsel. First off, the law officer of the Water Resource Department is asked to be careful while providing instructions to the learned counsel. First of her personal appearance is dismissed with. Matter since dismissed on withdrawal with liberty as paid for.
To file a fresh, my lord.
61.
61, my lord, impine order is, my lord, that your lordship will see at page 237, my lord. I being a, my lord, head assistant, I have been given, my lord, by virtue of the penalty, my lord. Without disclosing, my lord, my appeal and anything, my lord, they have given me simply on 6, my lord, and I have received on 11/6/24. Through WhatsApp only, not hard copy.
Which one? Which is the document?
Page 237. Last page, man.
Where is this order of 14/3/2024?
Penalty order, my lord, earlier penalty order, lordship will see at page press penalty, 198, my lord. Same dicto copy, my lord, has been 190.
198 is not the order.
No, sorry, my lord. 200, sorry. 200, page 29.
This independent challenge would not be maintainable because the appellate order.
My lord. Appellate order we have challenged, my lord. Just now they have given me copy, my lord.
That's why this has to be
Yes.
closed with liberty to challenge the
Or
appellate
can it
order.
be like this, my lord? Lordship fix the matter after vacation, my lord. In the meantime, I'll prepare, my lord. All the three matter be taken up together, my lord. And or lordship issue the notice with the interim.
No, because you see, after the punishment given in the disciplinary proceedings, after the appeal, this order would get merged in the appellate order. And therefore, that is something you'll have to challenge.
My lord, I challenge
Independent
individually because, my
challenge
lord,
to the
they have not
departmental
served me
order.
any copy of appellate order, my lord. Now today only, my lord.
That's okay. Because of the subsequent development, this has to be closed.
Or lordship, can it be like this, my lord? Lordship keep the matter alive, my lord, till after vacation, my lord. I'll file that petition subsequently, my lord, with the instruction that, my lord, we may.
Okay, on the, so J.I. Bhavya, counsel for the petitioner, the matter stands adjourned today. Mr. R.M. Das, the standing counsel for the Water Resource Department, is present. Okay, we have dispensed your personal appearance. But next time, don't withhold documents from the court. Okay.
My lord, item number 3, lordship has issued notice, my lord.
No.
Oh, yeah, lordship has not.
No, because the appellate order has to be challenged with this
Yes,
independently can't be.
Second petition which you have put money. Let's come up together. Only, my lord, till then, my lord, no corrective action shall be taken against me.
After punishment,
That undertaking has to be given.
after punishment, what else can be done?
My lord, if I go for joining, my lord, demotion of my post. I was head assistant, now they made me UDS.
No, we won't comment. That is beyond our capacity to comment.
Without application.
Item 4,
Obliged, then.
In this case, my lord, the principal, my lord, instructor, my lord.
Lordship, I have received instruction.
What is it? Just tell us.
Lordship, there's a battalion where he has been transferred, 41 battalion. It's in the same campus where the frontier headquarters Siliguri is located, Lordship. So it's a family accommodation and there is unit hospital also. And there is 4 kilometers nearby, there is a composite hospital for all the central armed police personnel at the BSF headquarters, Lordship. So, Lordship.
My lord, let him file affidavit, my lord. My lord, kindly see his representation, my lord, for a moment, page 58.
But you have been posted at a better place. You are posted near a composite hospital.
My lord,
and a family quarter.
My lord, his wife is now, my lord, the treatment here also, my lord. He stated in the representation also, my lord.
Pardon me? Page?
My lord, page 58, my lord, for a moment, my lord. In Ayurvedic hospital, my lord, Guwahati Ayurvedic Hospital College.
But no document has been annexed, Lordship.
My entire family, my lord, is suffering, my lord, medically, my lord. Petitioner himself, my lord, kindly see, my lord, third para, my lord. And he also stated, my lord, to first battalion SSB, my lord.
No, but everything can't happen according to you. If they are transferring you to a family quarter which is close to the composite hospital, you can't find fault with that.
It is going to be, my lord, VS, when he undertake, my lord, only in the representation, my lord.
And here he has since 2019.
Yes, my lord, that is true. But so that, my lord, that is why, my lord, he also, my lord, want to transfer, my lord, from, my lord, battalion, my lord, here, my lord, Unapur.
Mr. Dingia, with these instructions, we can't entertain your writ petition. There cannot be a better place like this. The 41 Battalion Headquarter, Rani Danga, is situated in the same campus with Frontier HQ Headquarter SSB Siliguri. Within the campus, there are 2 unit hospitals with doctors and medical staff. For any medical assistant, a well-equipped 100-bedded composite hospital with specialist medical attendants exclusively for force personnel and their family members is located in the nearby BSF camp composite hospital, Kadamtala.
And the distance Kadamtala to Rani Danga is 4 kilometers. I've checked out in the Google's lordship.
You can't have a better location.
My lord, my lord, at present scenario, my lord petitioner, my lord, with a brother, my lord, who is himself, my lord.
They are permitting you to take the family members.
Let them file affidavit, my lord.
It's not required.
But here, my lord.
Because we take into cognizance this, you see, this instructions is given to him by Deputy Judge Attorney General. So this is a man of some substance.
My lord, here, my lord, in battalion also, my lord, the family accommodation also, my lord, they are available. My lord.
No, but you are not availing family quarters. Here you are residing separately. Although there is a family quarter available in your present location, you are not availing official quarter. You are residing elsewhere.
Rented.
They are vacant, what you call, accommodation available in the present location. You are not availing that. You are residing at your own cost separately.
Due to, my lord, is medically, my lord, problem. And my lord, even my lord, the 1st Battalion, Hunapur, my lord, here, my lord, some, my lord, I have a, copy, my lord, where, my lord, facility, water facility is also available. Water facility is also available.
But you are not availing that. You are offered the facility, you are not staying at the government quarter. You are residing elsewhere.
Because due to my problem, my lord. My initially, my lord, the headquarter, my lord, in Guwahati, my lord, Khanapura. Now, my lord, shifted to, my lord, Hunapur, my lord.
Whatever,
But there is, my lord, 5 kilometers difference, my lord, between battalion and Manoj.
Once we are concerned with your family welfare and you are taken care of by the respondents, we are closing this rate petition. But Mr. Alan Dingia, Lanet, counsel for the petitioner. Mr. B. Chakravarti, Lanet, CG appears for the respondents. Next paragraph. In brief, the case of the petitioner is that that his younger brother is suffering from locomotor disability with 50% permanent disability in relation to his both upper and lower limbs. Stop. The petitioner being the caregiver, comma, his specially able brother is residing with him. Stop. The petitioner also claims to be suffering from low vision disability of his left eye, which occurred in an accident that the petitioner suffered while he was on official duty. Full stop. The petitioner further claims that his wife is also having certain medical condition and she's suffering from capital GBS oblique hypokalemia, HYPOKALEMIA, and SICCA symptom. And therefore, she has extremely low weight and cannot work properly. So stop. Accordingly, the learned counsel for the petitioner has submitted that as the petitioner is he is himself a specially able person and he has to give care to his wife as well as younger brother who are both specially abled, comma, the petitioner is exempted from annual routine or rotational transfer. Stop. Next para. The petitioner who is presently serving as a constable within bracket GD in the Shasastra Seema Bal has received there has been served with a transfer order dated
Page 54, my lord.
10/4/2024. 2024.
2024, thereby transferring him from his present location to 41st Battalion, Rani Danga, which is followed by a relieving order dated 13/6/2024. Stop. The petitioner has submitted a representation dated 15/4/2024 through official channel, while official diary number 2610 however, the said representation has not been addressed by the respondent authorities. The learned counsel for the petitioner has submitted that the impugned transfer order is in violation of the guidelines contained in the office memorandum dated 8/10/2018, issued by the director within bracket RES bracket closed, Ministry of Personnel, Public Grievances and Pensions Department of the Department of Personnel and Training, Government of India, as well as in violation of the transfer guidelines of the Sashastra Seema Bal personnel dated 4/3/2024, issued by the Inspector General within bracket first PERS bracket closed. Next para. The learned CGC has submitted that pursuant to order dated 21/6/2024, he has been provided with written instructions by the Deputy Judge, Attorney General, Frontier Headquarter HQ, SSB, Guwahati, whereby it is being informed that the new placing of a new place of posting of the petitioner at 41st Battalion, SSB, Ranidanga, is having well-established infrastructure with residential family accommodation. It is projected that it has very good infrastructure in terms of accommodation, connectivity, and medical facilities. So it is further informed that the said battalion is situated in the same campus with Frontier HQ, SSB, Siliguri, and within the campus there are 2 unit hospitals with doctors and medical staff, and that well-equipped 100-bedded composite hospital with specialist medical attendants exclusively for the personnel of CAPFs and their family members is located at nearby BSF Composite Hospital, Kadamtala. So the court is also it is further informed that the petitioner is presently not staying at government quarter at his present place of posting at Frontier HQ SSB Guwahati at Sonapur, despite availability of quarters. First of all, it is also informed that the new place of posting is closer to the hometown of the petitioner. And it is also informed that the petitioner has remained posted at the present place of posting for more than 4 years, whereas the normal tenure of posting is only 3 years. Full stop. In view of the projection that near the location where the petitioner is being transferred, there are 2 unit hospitals as well as a 100-bedded composite hospital. For the court is of the considered opinion that the said medical facilities available near the present in the transferred location of the petitioner it appears to be sufficient to take care of the medical requirements of the petitioner, his wife and his younger brother. Full stop. Moreover, as the normal tenure of posting was only of 3 years, and the petitioner has remained in the present place of posting for more than 4 years, the court is of the considered opinion that the transferred place of posting of the petitioner has the requisite medical facilities for the well-being of the petitioner and his members of the family. Full stop. Accordingly, the court is not inclined to interfere with the transfer order of the petitioner. Which page is the transfer order?
My lord, page 54, my lord.
64.
54, my lord. Annex 6. Petitioner serial number, my lord, page 55.
Intra-office note Your serial number is 65.
20485.
Yes, my lord, 65, my lord, in relieving order, my lord.
Oh, this is the relieving order.
Yes.
Page 63.
Yes.
What is the transfer order? Where is
Transfer
that?
order, my lord, page 54.
And his
This
name
transfer-
appeared in page 55.
55, my lord. 20485, my lord.
Transfer order being office order number, page 54. Wherein the name of the petitioner appears at serial number 20485 at page 55. Huh? As well as the impugn relieving order by into office note with date number under file number so and so, page 63. 13/6/2024. Mr. Chakravarti,
Lordship.
how much time you can give him to make movement?
He has been given up to 2nd of July. Time given up to 2nd of July.
2nd July is nearby.
Lordship.
Give him some more time.
Lordship.
How much? 10 days more.
Lordship.
The next part, as the court finds that the petitioner has time to report till 2/7/2024. In the court is inclined to direct the who will be the competent authority to give him time.
Respondent number 7, my lord, issued my lord relieving order, my lord. I think respondent number 5, respondent number 5 is my lord, Inspector General is the my lord.
5.
Respondent
So
number
5 will not give you time. 5 will not give you time. I think it will be 3.
Yes.
Mr. Chakravarti, Inspector General Personnel, Shastra Simabal, Arkepuram, New Delhi.
Lordship.
But my lord, transfer order issued my lord, respondent number 5, my lord. Transfer order was issued my lord, respondent number 4, my lord. Commandant my lord first.
No, transfer orders will always be issued by the Director General.
Heading.
Lordship.
I think it will be number 2.
Lordship. Lordship, number 2, my lord.
Issued by
Respondent
Director General. Because
Director
it's
General.
centrally, the order is generally issued centrally.
Lordship.
Lordship.
No, but now to give him time, who is the competent authority?
Lordship and direct respondent number 3, Lordship.
Respondent number 2 and 3.
2 and 3.
First one, according to the Director General, Shastra Simabal, within bracket respondent number 2, and the Inspector General within bracket pers PERS, bracket closed, Shastra Simabal, to grant further 10 days time.
15 days time, my lord, if lordship, my lord, because physiotherapy is also going on.
Another 2 weeks.
15 days. Time till 15/7/2024 to the petitioner to report at the transfer place of posting. Taking in view of the projection that the petitioner, his wife, as well as his brother, are all specially able. Okay. You'll be required to give a certificate copy. Certified copy to the
Certified
petitioner is
to-
permitted to send a scanned copy of the certified copy of the order to the said to authorities.
Item 5,
My lord, after the my lord, death of my husband, my lord, I pray for family pension, my lord. Actually, first wife, my lord, before my marriage, my lord, husband, marriage was solemnized with another.
Issue notice.
Lordship.
Heard Mr. H.K. Das and counsel for the petitioner, as well as Mr. S.S. Royal and the CGC appearing for the respondents. Next, the petitioner claims entitled to family pension with effect from 4/10/2019. From both arrear and the current. Next, I shall notice returnable in 4 weeks. Requisite extra copies of the reparation be served on the runner CGC in course of the day. Next, the pendency of the petition shall not be a bar for the respondent number 3 to ascertain the claim of the petitioner.
item 6,
May I please, Lordship?
When this matter was before the NCLT, did you make your claim?
No, Lordship.
But then your claim will be out.
No, Lordship.
Even if you see, this company was in litigation, in liquidation.
Yes, yes, yes.
There were advertisements issued to make claim.
Yes.
Once those claims are not before the official liquidator,
No,
your
no,
claim vanishes.
that claim, I think they have, as association, they have made, Lordship. Page number 36, this is a recent mail, Lordship. Page number 37, Lordship. It is a part of one email, Lordship.
We don't know about that. You show us that your claim was there before the liquidator.
Liquidator, that part, then Lordship finally adjourn this matter for week, Lordship. That part I have to get my instruction.
You get instructions because after that the government took over. The government also gave you an opportunity of making a claim,
Lordship.
and certain amounts were there. Mr. Borpujari would be knowing, I think. Nagaon paper mill, you are aware of it?
Yes, my lord, it is now under liquidation, my lord.
No, liquidation is already over. The state
Yes.
government has taken over the property.
Yes, yes.
Now, what has happened to the what do you call dues payable to the employees? Are you aware of it? No.
No, my lord, perhaps, my lord, Commerce and Industries Department, my lord, they will be in a better position.
No, because ultimately it goes to finance.
Finance, my lord, it is true, but my lord, as of
You
now,
are not
my lord,
aware.
I am not aware, my lord.
Okay.
Now, some my lord, semiconductor plant has been set up there.
Okay. On the prayer made by Mr. A.D. Chaudhary, counsel for the petitioner, the matter stands adjourned today to enable him to obtain instructions. List after answering. List in the motion column after answering some revision.
Yes. Obliged, Lordship.
Yeah, please, your lord. What if the matter relates to compensation appointment? The additional father was serving as master role worker under PWD Road Division from 96 to 2017.
2017, you will not be entitled to any consideration.
Lordship, after that also we have filed a representation, a detailed representation. This may be considered.
2017 is still claim. Under principle 10, you will not be entitled to consideration.
Lordship, then we have to file a representation on 16/5 on
That doesn't
22
help you.
consider. That is on
Principle
page
10 can't
number
be
20.
extended. Principle 10 of the case of Achyut Ranjan Das can't be extended. What is the prayer here?
Prayer, Lordship, to direct the respondent to consider him for appointment at grade 4 and pay the error salary.
That can't be possible.
Then your Lordship consider the Lordship representation, Lordship.
Pardon me?
Consider the representation.
No, that can't be considered.
That is on page number, Lordship.
No, every representative can't be ordered to be considered. Your name? You are Mr. M.K. Chaudhary?
P. Chakraborty.
P. Chakraborty. Mr. P. Chakraborty, learned counsel for the petitioner. And PWD who would be representing?
Yes.
Mr. Dhar?
Yes, Lordship. That is in respondent number.
Mr. R. Dhar, learned standing counsel for the PWD, representing respondent numbers 1, 2, 3. And BTR, and Mr. V. Chaudhary, learned standing counsel for the BTC, representing respondent number 4. Next para. The case of the petitioner is that his father, Arjun Lahari, Lahari, was serving as muster roll worker under the PWD Roads Division. And he died on 17/7/2017. The petitioner claims that he has. Where is your representation?
Sir, in Lordship, page number 20.
Page number
20, your Lordship.
20.
20 annexer F, last page.
So as per the representation, annexed to this petition as annexure F. It appears that the prayer of the petitioner was to provide him with the area salary of his father. However, in the prayer made in this repetition, the petitioner is seeking a direction upon the respondent and authorities to provide the petitioner with a appointment in grade 4. Next slide. So we notice that his claim would not even fructify. He'll not be, he has not been, his service is never regularized. His father's service was never
Lordship,
regularized.
from the documents annexed to the repair, it doesn't appear that he was regularized, or nor any other details is there, Lordship.
So there's no document to show that in this repetition, there is no document to show that the service of the petitioner was regularized, the father of the petitioner was regularized. Moreover, it is seen that the petitioner has not applied for a helping and compassionate ground in the manner prescribed. Stop. The stop. Unless the petitioner is able to demonstrate that the father of the petitioner was in regular service, the petitioner would not be entitled to make a claim for appointment on compassionate ground. Stop. Next, moreover, even assuming that the petitioner could have applied for appointment on compassionate ground, but in view of the principle 10 laid down in the judgment of this court in the case of Achyut Ranjan Das versus State of Assam and others, 1996 for SCC, for GLP, and in view of the OM dated 1/6/2015, the court does not find the petitioner to be entitled to appointment on compassionate ground. Stop. Accordingly, the writ petition stands dismissed.
Item 8.
My lord, in this case, my lord, to withdraw the, my lord, the retention of, my lord, government accommodation, my lord. My lord, as per the, my lord, notice, my lord, OM, my lord, 6 October 2022, my lord, page 97.
Yes, you had issued a notice, this notice. But Mr. Aaron Dingan and Council for the petitioner, as well as Mr.
On behalf of
Tahildar Lanet.
On behalf of Mrs. R. Devi.
Council appearing on behalf of Mrs. R. Devi Lanet CEC. The issue relating to holding of a family accommodation during posting at Northeast region is sub judice before various courts. First, accordingly, letter notice return within 4 weeks be issued. The as the done, CGC accepts notice on behalf of all the respondents. Requisite extra copies of the requisition be served on her in course of the day. Next paragraph. Till the next returnable date, coercive steps against the petitioner shall not be taken for retention of the family quarters while he is posted in the northeast region. List after 4 weeks.
That's my humble submission, my lord. Since my lord, his retention period is over, my lord, coming my lord 28, my lord. My lord, in the meantime, my lord, maybe my lord, respondent authority is to impose my lord some penalty, my lord. Impose some penalty action, my lord. My lord, lordship, my lord, earlier occasion, your lordship, my lord, the person order, my lord. Only can. Para 5, my lord.
Coercive action for eviction or recovery of penal rent against the petitioner who is presently occupying the family quarter. Okay.
9.
Right.
We are aggrieved by a recovery, my lord. Whereby, my lord, just before retirement, the basic pay was reduced without showing any reason. I till today, my lord, don't know why the basic pay was reduced from 5,800 to, my lord, 5,500.
Okay.
No instruction is necessary as per the information. As per the pay matrix, the post of secretary is category B. And Rafiq Masih case is not applicable here because they have given undertaking during revised pay calendar. And the Honorable Supreme Court passed an order in High Court of Punjab and Haryana and Jagdeep Singh case that in this case, my lord, they have given undertaking. And Honorable Supreme Court says that one who has given undertaking at the time of high pay scale, then he is bound by the undertaking. You see, this
That was the case of judicial officers, my lord, who during the pendency of the case gave an undertaking saying that we understand that the decision might be reversed, and therefore, my lord, undertakings were given and they were getting benefits. Then, irrespective of Rafiq Masih, my lord, at least reduction of pay, my lord, is otherwise deemed to be a penalty, my lord. Some notice and reason as to show cause has to be shown as to why the pay should not be reduced.
11 and 12, my lord. Para. And Rafiq Masih cases are considered at page para 10. Right?
When did you retire?
My lord, in September 2023.
September
2023. 1st September 2023.
23. Where is the impugned order?
My lord, there's only the recovery statement, my lord, at Annex 3. They have shown that
Page.
Page 15, my lord. They've shown that my pay was to be wrongly fixed, my lord, from 1st October 2008 onwards, my lord, when I had undergone a promotion, my lord, to Naib Subedar. From that juncture, my lord, they have indicated a recovery. And the total summary recovery, my lord, it comes to 4 lakhs 12,872 at page 18. This now has already been retained from my pensionary benefits,
Will issue notice.
my lord.
Yes. Heard. Mr. B. Patel, Learned Counsel for the petitioner, as well as Mr. A.K. Datta, Learned CEC, appearing for the respondents. Next one. The petitioner has superannuated from service on 1/9/2023 as Subedar (GD) in Assam Rifles. Stop. By the impugned recovery order dated 26/5/2023, the respondent authorities had reduced the basic pay of the petitioner and recovered a sum of rupees 4,12,872 from his retiral dues, which is under challenge in the presented petition filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the CEC in course of the day. Next, the recovery of rupees 4,12,872 from the retiral dues of the petitioner shall be subject to further orders that may be passed into the petition. Typically applied. Giving you back, Mr. Datta, this judgment.
Item 10.
Please, my lord. Petitioners, my lord, may have participated in a recruitment process held by the SSC for different, my lord, central police forces. They could not make it on the cutoff mark on the financial list, their marks have been shown to be less. Now, what happens is, if Lordship will kindly have page 22 of the advertisement for a minute. This was the advertisement. Starts at page 20. At page 22, my lord, clause 3.2.
But that is an advertisement 22. You can't keep a post vacant for you right
My
now.
lord, what has happened is they have declared the results in 2023 end. 2023 end, they have declared the results. What we are vying for is, for the clause, 10% of the entire reservations category wise was to kept for ex-servicemen. In case the ex-servicemen did not come in, these posts were to be converted to the regular candidates. Only 1% out of 349 for the state of Assam was considered under the ex-servicemen, and 348 posts remained vacant. Our apprehension is they will take these ex-servicemen posts from this recruitment process and include it in some other recruitment process. Only to that extent, this honorable court in other similar petition has given the orders also, my lord. From the ex-servicemen posts which were vacant in this recruitment process, from that equal to the number of candidates have been kept vacant. It is not from an overall vacancy that we are asking for that.
You participated in that
Yes.
process. And you were unsuccessful.
For the regular candidates. In the regular candidate part, we were unsuccessful. Now, for the ex-servicemen, they had kept aside 10% of the post. Per the advertisement, that is what I was pointing at page 22. 10% out of the entire post will be kept for ex-servicemen at
No,
page 20.
you offered one candidature, not two candidatures.
One, no, we will be considered under the ex-serviceman category because they say it will be brought into the regular mode. And we will be considered against them is their statement.
Where is that?
Because you will find it page 22.
Yes.
3.2, my lord, the clause 3.2.
No, but then you see, once you participate in the recruitment process,
yes,
you'll have to participate as a ex-serviceman category.
No. Here they say that if ex-servicemen are not available, then non-ex-servicemen will come in. Regular candidates will come in. 10% vacancies are earmarked for ex-servicemen. If suitable ex-servicemen candidates are not available, vacancies reserved for ex-servicemen will be filled up by non-ex-servicemen candidates of respective categories. Out of 3,000 posts, they kept 300 for ex-servicemen. One post filled up by ex-servicemen. Now, non-ex-servicemen persons of the respective category will fill up those posts. Our apprehension is instead of filling it up in this recruitment process itself by considering us, they will be transferring it to some other recruitment process. So unless and until they adjust the number of non-ESM candidates, including us, if we make it on merit, those should not be filled up by some other.
But results are already out.
That ex-servicemen post results have not come. Only one person was selected. 348 posts remain vacant.
But after the declaration result, you see, Mr. Mazumdar, the recruitment process ends.
Yes, but when they declared the result for the ex-servicemen, they declared only one person successful.
Yes.
For the advertisement, these other ex-servicemen posts, the non-ex-servicemen people had to be considered. Not their case that it has been considered because someone or the other would have filled it up from their respective categories. It could not be kept vacant. And so far as the ex-servicemen posts are concerned, the recruitment process is not over yet. Because someone or the other from the non-ex-servicemen had to be considered against them. Those posts, not done. Our claim is on merit, we would have come in. Since not done, therefore, Lordship may find at page 115. Starts at page 100, page 99, page 115, my lord, in a similar batch. This honorable court has been only pleased to keep the number of posts of petitioners in the ex-serviceman category, which they have not filled up to be not to be filled up. What are the other posts? We cannot have a claim.
What is happening to this?
Lordship, I have to take the instruction whether it has been filled up or not, Lordship, because results are declared in the year 2020.
General posts filled up.
Whether it has been
non-ESM other posts filled up.
No, in the last writ petition,
Lordship.
notice was already issued. You have got any instructions? No.
No, Lordship. To that, I have to. Dear Lordship, I have been impaired, Lordship, but no instruction has yet been received. Today morning I have consulted Lordship.
Right. Mr. R. Mazumdar will counsel for the petitioner and Mr. S.S. Royal and SCC appearing for the respondents. Issue notice returnable within 4 weeks. Requisite extra copies of the writ petition be served on the CEC in course of the day. Next for that. The case of the petitioner is similarly situated to the petitioners in WPC.
General
2525 of 2024. which were in which notice of motion was issued by order dated 17/5/2024. Stop. In terms of this said order dated 17/5/2024, passed in WBC 2525/2024, as an interim measure until the next returnable date. 1. Post of constable within bracket GD in Central Armed Forces within bracket CAPF small s dash to 2022 out of
348, my lord.
page
340, Lordship will find it page on the order itself, 116, just the para above.
page number.
No, page 116 in the order itself it is given.
No, here in this advertisement, where is that page you were showing us?
The number of vacancies. Number of vacancies.
No, 10% that you were showing us.
10%, that is page 22.
Page 22.
22. Serial number 3.2.
Out of vacancies mentioned at paragraph 3.2 of the notice. What is his date?
Notice number is given, madam. They do not give a date. Number Lordship will find below the table. 27 10 2022. So 9 for
27 10 2022 within bracket annexure A. Shall be kept vacant till the next date of listing. The 3.2 in respect of constable within bracket GD in CAPFs dash 2022 shall be kept vacant till the next day of listing. Next list of the 4 weeks on date to be fixed by the office.
There are 8 petitioners. There are 8 petitioners.
Only
I'm sorry, 9 petitioners.
9 petitions.
9 petitions.
9 posts.
I'm deeply obliged.
11.
Yes. Yes, Mr. Baral.
My lord, as per service book record, my lord, date of birth is 31/3/1970. My post also has been regularized from master to regular grade for employee. But they have issued the interim release order, my lord. NXRF page 29. Right now, I am 54 years old, 54 years of age, my lord. And I will be retired in the year 2013.
Where is your service book?
Service book from page NXRD, page 27. Date of birth by Christian era. 31/3/1970. In my GPF account also same date of birth recorded, 31/3/1970.
Something is wrong. Your date of birth is 1970. So you joined service in 13 years of age.
That is exactly that is what, my lord, I have calculated. I have made a calculation. His date of joining is 1/10/83. Date of retirement is, if you go by annexure C, it is 3/1/24.
Once you joined, you will be presumed to be an adult.
My
At
lord,
13 years of age, you could not have joined.
my lord, annex, it is their record, my lord. They have recorded, man. The record is there, man.
So you joined,
Annexure
you
C,
see,
page 25.
you joined in the age of 13. Can it be possible?
My lord, they have recorded. And my lord, I have enclosed my school certificate, my lord. Annexure A, page 22.
Also, we should notice you take a call.
My lord.
And Mr. D. Bora, and is also for the petitioner. Also heard. Mr. R. Dhar, and standing also for the Handloom, Textile and Sericulture Department, representing respondent number 1, 2, and 3. Accountant General, you have Mr. R. K. Talabgar, and it's standing also for respondent number 4, and Mr. R. Pujari, and it's standing also for the respondent number 5 are present. The order dated 30 January 2024, issued by the respondent authorities to release the petitioner on 30 January 2024 is under challenge in this writ petition filed in Article 226 of the Constitution of India. So issue notice of motion, return of it in 4 weeks. Requisite extra copies of the writ petition be served on the Runner State and Departmental Council in course of the day. Stop. It appears from the projection made in this writ petition that the petitioner was allowed to join service when he was 13 years of age. If which is based on the projection made by the petitioner that his date of birth was 31/3/1970. List after 4 weeks. So the release of the petitioner shall be subject to further orders that may be passed in this writ petition.
Thirteen.
May I please?
Yes.
Lordship, the matter is for Lordship equalization of pay, Lordship. Finalizing pension by considering my date of appointment as 15/7/1981, Lordship. These two pairs are rejected by way of a speaking order, Lordship. And speaking order was passed pursuant to the court's order, Lordship.
Mr. S. Talukdar
I have challenged this speaking order, Lordship.
petitioner and also Ms. Egal and it's secretary for the respondents. The petitioner claims equalization of pay with other similarly situated persons and is agreed by the impugn order dated 7/6/2019, by which the claim was rejected. To notice a motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the runner series in course of the day. Next list after 4 weeks. What about provisional pension?
Lordship, Lordship, I have not been paid the provisional pension, Lordship. I have a simple prayer, Lordship, for it as an interim to release the provisional pension, Lordship. And that prayer was earlier considered by this honorable court itself, Lordship, which I have annexed also. Annexer, Lordship, you will page 56. Interim prayer was considered, my Lord, and despite of that also, Lordship, that have not been released, Lordship. I got retirement from service on 39/2018, Lordship.
My lord,
Why you filed the writ petition here? You obtained the earlier order at the High Court of Jharkhand.
No, Lordship. Subsequently, she was posted before the respondent of 5, which is under the jurisdiction of this honorable court, Lordship. And I got retirement from service, Lordship, under Lordship respondent number 5, Lordship.
lord, my lord, regarding interim prayer, my lord, I may be allowed to take instruction as page number 63, order of this honor, our High Court, my lord, last order. page number
60.
61, my lord.
61, my lord.
61 is that, my lord, last order?
57.
Yeah, 50?
57 interim order.
57 interim order. The final order is, my lord, page number
61.
61. And in the relevant portion is in 63, my lord. Paragraph 14. In order to expedite the process, the petitioner may furnish a fresh revision to the authorities within a period of 1 month from the day with supporting document which shall be examined by the respondent authorities, more particularly respondent number 2, and disposed of by issuing the speaking order by intimating the decision thereof the petitioner. Decision regarding the similar pay scale, my lord. I will be allowed to take instruction
Already
regarding that,
speaking
my
order
lord.
has been passed, Lord. So it is next are X.
No, that's
Reject-
okay, but
reject
once
the first.
whatever was the last pay drawn,
Lordship.
on that basis, you can give a provisional pension,
Yes.
Lordship.
Last payment.
last pay drawn.
Yes, my lord.
So the pendency of this repetition shall not be about the respondent authorities to examine the claim of the petitioner provisional pension on the basis of last pay drawn. List after 4 weeks.
Last of
Lordship, the date of appointment will be subject to outcome of writ petition, Lordship. My lord, the date of appointment will be, Lordship, whether Lordship my interim is Lordship considered regarding provisional pension, Lordship.
No, please tell us what you want.
Lordship, provisional pension, Lordship.
No, that we have already ordered.
Yes.
Lordship, yes, Lordship.
Date of joining can't be open.
Date of joining, Lordship. Lordship, this is only the issue, Lordship, for which I have not signed,
No,
Lordship.
that will then dismiss your petition because you went to High Court of Ranchi. There you got an order that you will be considered for permanent employment from a particular date.
Lordship.
That date is already mentioned in the Ranchi High Court order.
Lordship.
Now we can't reopen that.
No, Lordship. That is not followed, Lordship. That is not followed. So far, Lordship,
No, if it is not followed, you file contempt before the appropriate court. But this is not we can't re-adjudicate that matter again.
No, Lordship. I have challenged the speaking order here, Lordship. Here, speaking order, Lordship. By which my claim has been rejected, Lordship. And Ranchi High Court's order was complied by the authority by passing an compliance order, Lordship. And thereafter, Lordship.
No, but that date is crystallized.
Lordship.
From which date you should be considered, that is crystallized.
Lordship.
We can't reopen that.
Lordship. Already, Lordship. Already.
No, please take your call. You say that it has been complied with. Once it is complied, why should we reopen again?
Lordship. They have complied with stating that they will consider my date of appointment as 15/7/1981, Lordship. Thereafter, Lordship, they have, Lordship, published on one of my personal details, Lordship, wherein my date of birth, date of appointment has been shown as shown in the year 2010, Lordship. In one hand, Lordship, in the speaking order, they have stated me that I am.
No, if that is
not
wrong, you
competitive.
go and that's an order of that will be a matter of
Lordship.
contempt between the court which has passed the order.
Lordship.
We can't re-adjudicate and reopen that again.
No, Lordship. They have complied the order, submitted a compliance order before the Honorable Supreme Court, Lordship.
Then file a contempt. What can we do?
Lordship. No, Lordship. The subsequent issue, Lordship. Due to the subsequent issue, I have filed this petition.
That will consider.
Lordship.
What's up, sir?
Item 14.
I'll take a break and come back.
Please, Your Lordship. Lordship, hearing the petitioner has worked for about 38 years under the Public Health Engineering Department, Your Lordship. Initially, he was appointed as a master roll worker, Your Lordship. Thereafter, he was engaged as a khalasi in the year 1984, Your Lordship. The engagement order is at page number 17 and 18, Your Lordship.
We should notice you examine the claim of the petitioner.
Apparently, writ petition is not maintainable because he is seeking regularization, my lord.
Now
Not
regularization,
regularly, even you can, because you are extending that facility of pen dash to others.
no, he
Yeah.
has already, he is not in service as of now.
I understand, but post facto it can be done if you have done for others.
Post facto, my lord.
In fact, they have themselves written, your lord. They have themselves written at
No,
page
that's okay,
number.
but once you have retired, he's saying the right thing. Because once you have retired, the situation
And my
gets
lord,
altered.
his service was not paid by the government. So rule 31, my lord, will not be attracted, my lord. Kindly see, my lord, page 17 of the writ petition. Proceed may be pleased to notice, my lord, keeping the issue of maintainability open. Page 17 is the, my lord, initial appointment order which
No,
he
but
claims.
pastoral workers, you have done it for so many people. Why
No.
one should be left out?
Page 17 is the appointment order.
Pump operator.
Yes, pump operator. Now, my lord, it is seen from this appointment order, my lord, that a scale of pay has been, my lord, given to him. That a definite scale of pay was given to him.
Yes.
But, my lord, down below, lordship will find that the copy of this appointment order was not, my lord, forwarded to the treasury officer, meaning thereby, my lord, that the salary was not paid by the government. It might have been, my lord, an official arrangement. Then, my lord,
Inquire into the matter, let us see.
my lord, what I find from the writ petition, then page 20 also, my lord, page 20.
20, yes.
20. They are engaged, my lord. They are re-engaged. This is a, my lord, of letter dated of, my lord, 1992. In page 20 also, lordship will find down below, my lord, copy has been marked to all the authorities, but not the treasury officer. So it is not paid by the government. So definitely rule 31 is not affected. My respectful submission, my lord.
No, that's okay. We're not saying you're incorrect. But still have it examined.
Lordship may be pleased to keep the issue of maintainability open, my lord.
But this says they learn counsel for the petitioner also have. You are paying for this PhD. I bought a good on it. Standing counsel for PhD representing respondent number 1, 2, and 3.
1, 2, 3.
And Mr. R. Vijay run it. Standing counsel for the finance department representing respondent number 4 and
6, my lord.
6. And Mr. C. Barwal on it. Standing counsel for the respondent number 5. Next, keeping the issue of maintainability open. Issue notice returnable in 4 weeks. Requisite extra copies of the requisition be served on the Honor State and Department Council in course of the day. That's why I'm taking note of the fact that the petitioner claims to have superannuated when
30/11/2021, your lord.
30/11/2021. The respondents are directed to provide their respective standing council with the appropriate instructions.
Much obliged.
Supply item 57 with 58 for motion.
Lordship, may I please, Lordship, kindly pass over the matter for timing, Lordship. Learned CGC lakes in another court. 57. Thank you.
After some time.
Yes.
$59.
Item 59.
petitioner before your lordship has applied for the various posts under the staff selection commission pursuant to the advertisement dated 21/7/2018, your lordship. Otherwise, the petitioner belongs to the reserved category. He's from the ST community, your lordship. Now, if your lordship
Yes.
kindly takes up page 42 of the advertisement. Lordship, got it.
But what about the delay in 2018's recruitment 21, the results are declared. You've come after 3 years.
Okay.
Mr. Bordoli, that itself disentitles you.
Lordship. There's a delay, your lordship. Good on.
What is your score? And what is the score of the last person selected in your category?
It's 45.44250, and the petitioner scored 45.53122, your lordship.
Where is your marks?
Annexure 5, page 59, your lordship.
59.
Lordship. Yes, sir.
You scored 45.53122.
122. Lordship.
And what is the last selected candidate?
So page 58, your lordship. The cutoff mark, if your lordship kindly takes up the 6th column from bottom, your lordship. Page 58,
Sixth column from bottom.
The postcode is E, that is ITBP, and the area code is G, that is the general districts. And the category is unreserved, UR. Here the score, last cutoff mark is 45.44250, your lordship. Under the reserved category, there are candidates who have scored more than the petitioner. But your lordship, under the unreserved category, the last cutoff is 45.44250. And in fact, your lordship, if your lordship kindly takes up Annexure 3, page 52, that is the physical standard test, your lordship. Page 52, Annexure 3. Prescribed physical standard, the height. Lordship, second column, the minimum height for all the candidates belonging to the scheduled tribes will be. For male, it is 162.5, whereas the petitioner's height is 167, your lordship. And that apart, lordship, the next page, page 53, the minimum chest for all male candidates belonging to scheduled tribes will be 76/81. The petitioners is 78/85, your lordship. So under that circumstances, your lordship, we have not availed the relaxation.
Okay. Issuing a notice.
Yes, there's a vacancy not available. Vacancy not available.
Not available.
Not available.
No, but he's claiming that once once he has scored more than the unreserved category,
Yes, that's it.
then he would have come in otherwise also.
Yes,
Heard. Mr. G. Bordoli and counsel for the petitioner and Mr. S. Barwal and CEC appearing for the respondents.
Similar, may I please also, similar matters are disposed of by direction, giving a direction, petitioner may be accommodated against the vacancy arises from any other departments. This,
Where are the orders?
lordship, I have already annexed the lordship.
that order is previous, recent order is, I have.
Annexure 6 are the earlier orders, your lordship.
No.
The recent order, your lordship.
You did not file any appeal against this order? But Mr. Bodole, we can't, although another bench has passed such an order, but we can't do this. This will be not an implementable order because the Supreme Court has already said. And following that, even this court has passed various orders on the point. You see, once a recruitment process comes to an end, whatever vacancy arises will go to the next selection process. We can't have a reservation out of candidates for the present present lot for that. Because the only way you can have accommodation is to challenge the appointment made of somebody else. You can't have reservation for the next for the next recruitment. You tell us how to implement this order.
Otherwise, the vacancies are filled up. Vacancies are filled up. Vacancies are filled up, Your Lordship.
Then
In this situation,
suppose we find somebody eligible now in the recruitment process which ended in 2022. Now to say that in the future vacancies, they will be accommodated. That is absolutely not permissible.
In that case, Your Lordship may issue notice, let them come with some instructions.
Yes, Lordship. Notice have to go.
Mr. Juvenile Counsel for the petition is as per all and CG appearing for the respondents. Next paragraph. The petitioner claims that in the recruitment process for filling up of Constable GD in CAPFs, NIA, SS and Rifleman GD in Assam Rifles. Comma 2018. Which was advertised on 21/7/2018 by the Staff Selection Commission. The petitioner offered his candidature. He belongs to ST category and had scored 45.53122. So stop. It is submitted that his score was higher than the unreserved category candidate. Which page, Mr. Babur?
It's 58, Your Lordship.
58.
sixth column from bottom.
In this regard, the learned counsel for the petitioner has referred to the category was result. Final results declared on 21/1/2021. We are projecting that that for Assam region, the unreserved category candidate who was selected had obtained 5.44250 marks, which is lower than that of the petitioner. So accordingly, it is claimed that the petitioner should have been considered for appointment as a unreserved category candidate. Next one. The learned CGC has submitted that as per her instructions on all the posts. Under the advertisement dated 21/7/2018, for which results were declared on 21/1/2021 are all filled up. Full stop. Accordingly, keeping the issue of maintainability open, issue notice of motion returnable in 4 weeks. Requisite extra copies of the petition to served on the learner CGC in course of the day. Next, list after 4 weeks. That's okay.
62.
Made pleasure, Lordship. Lordship, on 14/12/2023, while I was serving as a junior engineer PhD department, a case was registered under section 7A of the Prevention of Corruption Act. Thereafter, on the very next date, on 15/12, I was arrested. And on 17/1/2024, my lord, I was released on bail. And on 19/1/2024, when I went to join my office, then my lord may kindly see my page 25.
But show cause notice has been issued to you.
Yes, my lord, show cause notice was issued. That is within time. But my lord, from the date of my suspension till date, my lord, no, my lord, review, my lord, nothing, my lord. And I am still getting, my lord, 50% of my salary, my lord. No enhancement, my lord, nothing. And my lord, the show cause, my lord, if your lordship kindly peruse the page 30, my lord.
Page 13.
Page 30, 30.
30, yes.
Statement of allegation, my lord. Lord, I am reading, my lord.
Oh, don't read because this is not, we are not going into the correctness of that.
My lord, both my lord, criminal proceeding and disciplinary proceeding are based on, my lord, identical and similar set of facts.
So what is wrong in that?
So, my lord, as per my lord, Anthony case, my lord, my lord,
You tell us how you are prejudiced.
Proceeding maybe, my lord,
You tell us
state,
how
my
you are
lord,
prejudiced. How you are prejudiced with the criminal and the criminal trial and the departmental proceeding on the same.
My lord, here, my lord, statement of allegation, if your lordship peruse, my lord, it pertains to, my lord, demanding of bribe and accepting of demanded bribe. And my lord, in the
How you are prejudiced? That is the question we are asking.
Well, because, my lord, this is the same allegation, my lord, in the FIR, my lord, till date, my lord, no charge sheet, my lord, in the PS case, my lord.
Doesn't affect either the civil, either the criminal proceeding or the proceedings in the departmental proceeding.
That is there, my lord. But my lord may kindly, my lord, as per my lord,
So
simultaneous.
there is a bar
continuous.
is referring to Anthony's case.
Yes, my lord.
So you'll have to overcome that.
My lord, if the departmental proceeding and criminal case are based on identical and similar set of facts, my lord, what my lord, the Paul Anthony case, my lord. The whole, here,
But
my lord.
we are still telling you, you not don't suffer any prejudice. You have to respond to that particular query.
Because my lord, if I, my lord, disclose here, my lord, my in the PS case, my lord, my lord, charge sheet has not yet filed.
So the criminal trial will proceed according to the proceedings of the disciplinary proceedings. On that basis, the trial will proceed in a criminal court.
No, no.
How does the trial proceed in the criminal court?
My lord, issue, my lord, identical and same, my.
Please tell me, I'm asking you a question.
Yes.
It's not, I'm just asking just for fun. I'm asking you a question. How will the criminal proceeding, according to you, shall proceed?
My lord, criminal proceeding will proceed, my lord, after filing of the charge sheet, my lord.
On what basis? What is the basis of a prosecution in a criminal case?
My lord,
It is the police papers.
yes, my lord.
Correct.
Yes.
So police does not have an access to your departmental records.
And my lord, may kindly one more aspect, my lord, the witness, my lord. Here, my lord, the superintendent of police is the main witness in the, my lord, the criminal proceeding. And my lord, he is also the same, my lord, the witness, listed witness of this, my lord, particular disciplinary
How
proceeding.
does that prejudice you? We are asking you again and
My
again.
lord, if I disclose my lord, if I have to disclose my.
So the police will
evidence, my
go
lord, it
there
will
in the
affect
criminal
my
trial and
proceeding.
give a statement which is contrary to 161 statement. A witness in a criminal proceeding will go and stand there and then tell the court that in the departmental proceeding, this was the question asked, and therefore now I am reframing my statement under 161. And although I have stated in 161 something else, but now I am changing my stand. That is how the superintendent of police will give his evidence. And the lawyer of the delinquent, he will be very happy with that sort of evidence being led, and he will not know how to defend his client. Don't tell us that. Paul Anthony is, we respect that because it's an order of the Supreme Court. But you tell us how will he suffer prejudice? And is in the departmental proceeding, you expect that the departmental authorities will request the chief what you call this special judge Assam, get its record, and then exhibit it in the departmental proceeding. Although in the statement of allegation, the statements are not there, the documents are not listed document. Still, in a departmental proceeding, you expect the department to give evidence on the basis of records of special judge Assam.
No, my lord, may kindly, my lord, if you
We are asking you, we are telling you the circumstances. Now tell us how you are prejudiced.
My lord, I'll be prejudiced, my lord, because my lord, in the statement of allegation also, my lord, and in my lord, may if your lordship kindly peruse the my lord.
It's okay, you took a
FIR, my
bribe.
lord.
You took a bribe and you are suffering for that.
My lord, it's a allegation, my lord.
No, that's okay. But the fact is that both of them proceed in a different
Different
set of documents, different set of allegations.
I'm not on that. I'm not saying that the disciplinary proceeding and the
Then you
criminal
won't suffer
proceeding
any
cannot
prejudice.
go together. They both can go together, my lord. But here in my case, my lord, as the my lord, facts and my lord, everything is my lord identical and similar, my lord. That's why, my lord, I'm my lord, till my lord.
But you're not suffering any prejudice. Now let us say are you prepared to give an undertaking that if the departmental proceeding is stayed, and let us say after the end of trial, even after 10 years when the departmental proceeding starts again, you would not take a plea that about the delay. You waive the you are prepared to waive any delay that is caused in the criminal trial, that you would not take the plea of prejudice on the delay. Witnesses will after 10 years will not be available.
With that effect, my lord, I have to, my lord,
So that, my lord, my subsistence allowance, my lord, in last 6 months, my lord, that
No,
has
that's,
not yet
that's
been
one
reviewed,
part.
my lord.
But yes, there's no, is there any order of
Suspension.
review?
Yes, Your Lordship, since the suspension was issued in the month of January, so I'll just get the instructions whether suspension has been reviewed or not.
My lord, that must be, my lord, furnished to me, my lord. Reason order must be furnished to me, my
So
lord.
let them take instructions. Can you get it by 2 o'clock?
I'll try, Your Lordship.
Try, because otherwise the courts will be on vacation for 2 weeks. You get the information.
Otherwise, Lordship, date may be fixed immediately after vacation.
My lord, my
Okay. Mr. M. Dattal and Constitutional Petitioner, as well as Ms. M. Kalital and Planning Counsel for the
PhD.
EHC Department, preparing for all the respondents.
Except respondent number 4. No. All the respondents.
Next, the continued suspension of the petitioner. From by order dated 18/1/2024 on and from 15/12/2023, the date of his arrest, is assailed in this petition filed under Article 226 of the Constitution on India on the ground that there is no review of the order of suspension. Issue notice of motion returnable on 19/7/2024. Requisite extra copies of the requisition be served on the learned state and learned department council in course of the day. The pendency of the repression shall not be a bar for the respondent authorities to release the revised subsistence allowance to which the petitioner is found entitled to.
the date may be fixed.
This comes with.
Highly obliged.
Obliged.
Item 46 for orders.
May please, your lordship. My lord, order dated 9/11/2016. My lord, is yet to be complied with. My lord.
Yes, you initiate contempt then.
My lord. Yes.
Does he? What was this?
So here is, my lord, with regard to framing of rules, my lord, service rules, my lord, with regard to the post of extra writers. That was, my lord, the dictum of the writ court. Thereafter, my lord, because here lordship will kindly appreciate, my lord, here almost, my lord, 6 departments are involved, not only the revenue department. I am representing the principal secretary of the revenue department. Now everything was moved, my lord, views of all the departments were taken. Lastly, my lord, the two posts are sought to be merged now. The extra writers, my lord, who were the petitioners therein, my lord, in the writ proceedings, with that of junior assistant, in order to bring a parity, my lord. Now, the file was moved before the finance department. Finance department raised queries, my lord. Thereafter, the finance file was again, my lord, submitted to the finance department. I have today, my lord, morning taken the telephonic instructions. We have received the file, my lord, from the finance department. Now, my lord, the revenue department is working on it, my lord. The financial implications will have to be ascertained, my lord, on the, my lord, data given by the Inspector General of Registration. That is now being done, my lord. And thereafter, my lord, the matter will be placed before the Honorable Cabinet, my lord, for taking a policy decision. Well, order of the writ court, my lord, will find my lord, at page 14 is the
No,
authority.
but why you are doing that exercise? The direction of the court is that you'll have to do it within the ambit of 210 rules, 2010 rules,
Yes,
which is Assam Registration Service Rules 2010.
Yes, now, my lord, paragraph 23 says in view of the reasons stated above, it would be in the interest of if some middle ground is found by the government, in as much a new post may be created, which should have higher pay scale than the extra writers, which should enable the extra writers to be promoted to the next higher post. In respect of the state government, would have to consider modifying the 2010 rules. Now, this exercise has been done. There was no post called, my lord, extra writers. But there is a post called, my lord, junior assistant, which lordship will find in the instructions which I have just now placed. So therefore, my lord, these two posts are now sought to be merged. Now, if these two posts are merged, my lord, then it will, my lord, entail in financial implications. Now, that aspect of the matter was duly examined by the finance department. Finance department, my lord, had raised certain queries, but the file was again resubmitted. It has now come back to the revenue department. So the authorities are sincerely working on it, my lord. This is my respectful submission. There is a delay, my lord. Of course, there is a delay, my lord. And
you bring it on record by filing an affidavit.
My lord, I have already filed two affidavits. My lord, I am representing the respondent number 6. One affidavit was filed, my lord, on 10th of November 2023. And my lord, thereafter another affidavit was filed, my lord, additional affidavit. Lordship will kindly grant me, my lord, 4 weeks time, my lord, I will get the updated instruction and incorporate in the form of an affidavit. This will be the third affidavit that will be filed by the respondent number 6 here, my lord. Because he is heading the department, revenue department. He is the principal secretary. One affidavit in opposition, my lord, it was filed on 28th of June 2023. Thereafter,
That is by respondent number 6.
Yes, my lord. Respondent number 6, my lord. He is the highest authority, my lord, in the revenue department. He is answerable, my lord. So leaving aside all other authorities, my lord, because here lordship will kindly appreciate, my lord, for my lord, modification of the service rule, or my lord, for that matter, my lord, framing of service rules, my lord. Several departments are interconnected, my lord. It is not that, my lord, we can take a solitary call. Only because of that reason, my lord, the matter was, my lord, has got delayed, my lord. So I pray for, my lord, 4 weeks time, my lord, I will get the updated instruction and it will be done, my lord. It is not that it will not be done, my lord. Lordship, from the materials on record, lordship will kindly appreciate, my lord, the authorities are sincerely working on it. But my lord, admittedly, there is a delay, some delay, my lord, that I admit, my lord. But for that, my lord, lordship may not penalize, my lord, the condemners.
But Mr. M. Islam, let me counsel for the petitioner. Mr. R. Borpujari Leonard, counsel for the respondent number 6.
My lord.
Has produced a copy of written instructions dated 12/4/2024 to project that the finance department is simultaneously taking up the matter with personal B department, judicial as well as legislative department. Because in terms of the judgments on order dated 9/11/2016 passed in WBC 3109 of 2014, the appropriate government is required to amend the Which rule you have to amend? Assam Registration Service Rules, 2010.
Now here, my
So
lord,
as to create a promotional avenue. To the extra writer. So it is also submitted that as per the proposal. Two posts are required to be amalgamated or merged. So as to create a promotional avenue. It is submitted that although there is a delay, but the respondent number 6 is working on the he is taking steps for compliance of the order of the court. On the prayer made by the Learned Council for respondent number 6. Stands adjourned today, list after 4 weeks.
lordship, I will file another additional affidavit. This will be the third affidavit.
The respondent number 6 shall file an additional affidavit to bring on record the
updated status.
Updated status of the compliance of the order of the court.
My lord, with manual pay structure of the my lord new post, my lord. Pay structure of the my lord, because pay structure has not been
That will
mentioned.
come after that. Now nothing is there because unless there is a post created, there will not be any pay structure.
Therefore, my lord, the finance department was moved, my lord.
47.
I'm
Highly
obliged.
obliged.
Your lordship.
Lordship may peruse the last order, Lordship. The Lordship had made a.
Yes.
Lordship, for the amount, the finance department, they have already sanctioned the area salary amount, Lordship, which was remaining, Lordship. That payment will be, from what I've been told, the payment will be made within 2-3 days. And the non-practicing allowance has also been paid to the petitioner, from what I've been informed, to a amount of approximately 10 lakhs, Lordship. So, Lordship, if some.
Okay, you've given a copy of this to
Lordship,
Dr. Lakar.
Lordship, regarding the payment of non-practicing allowance, I have got this to say, Lordship, that I have a copy of the bill as per which the payment has been made. May I submit a copy of this?
Lordship, now he is disputing the quantum of amount, and Lordship, he is
Lordship.
getting into all these technicalities, Lordship.
Lordship, in this bill, 36 months of payment has been withheld, Lordship. On the last column, Lordship, on the left-hand side, on the last column, this is 11/107/2012 to 31/03/2016. And on the right, towards the right, Lordship, it has been taken as 9 months. This duration of this period duration is 45 months, and they have computed as 9 months, Lordship. And at the rate of 16,020 rupees, they have paid 9 months NPA. But the period, this period from 1/7/2012 to 31/3/2016, this span is 45 months. And they have paid only 9 months. They have taken it as 9 months, Lordship. This is simply
This is wrong.
Lordship, why they have done this, Lordship, I am not aware. This has been produced to me.
Apparently, it is wrong.
Yes, Lordship. This period cannot be 9 months. It is 45 months, Lordship.
Lordship, whether this.
So 36 months.
Lord-
amount.
Because you see, in a contempt, you'll have to come clean.
Yes, Lordship.
If you calculate from 12 to 16 and say it is 9 months, apparently it is incorrect.
Lordship, then we'll maybe from the record, Lordship, I do not have an explanation for why this calculation.
To do it, we give you time, but do it.
Yes, Lordship, we'll come up with an explanation regarding how the amount has been calculated. Otherwise, Lordship, the area salary amount for the earlier period has already been sanctioned. So now only this.
Heard the petitioner in person. Mr. A. Chalian and counsel for respondent numbers 1 and 2 has produced a copy of sanction order dated 24/6/2024. The project that a sum of rupees 1,09,328 has been sanctioned for payment to the petitioner or to the petitioner in person towards area salary for the period of 1/1/1997 to 6/1/1998. So it is submitted that as per his instructions, the said payment would be created to the account of the petitioner within 5 to 7 days. That's better. The petitioner in person has produced a copy of bill towards this is for area salary.
This area
This is for non-practicing allowance.
For area non-practicing allowance. So it is submitted that that he has nothing to say with as regards the calculation made for a period from 1/10/2007 to 36/2012. However, in the column for area salary from 1/7/2012 to 31/3/2016, although the period is 45 months, but in the calculation portion, the calculation is made on the basis of 9 months. So accordingly, it is submitted that it's incorrect area statement is being shown by the principal comes chief superintendent, Assam Medical College and Hospital. Stop. Next one. Apparently, the period from 1/7/2012 to 31/3/2016 is not 9 months. Stop. Therefore, the respondents are directed to revisit the calculation made in respect of the non-practicing allowance of the petitioner in person. Stop. The sanction order you have got?
No, Lordship, I'll just.
Okay. In the meantime, the sanction order as produced by the learned counsel for the respondent number 1 and 2 be provided to the petitioner in person. Next list on. We're listing it on 29 July.
29 July.
Okay. 29 July 2024. You ask them to.
Lordship, we'll
revisit
clarify
the
on this.
calculation.
This we'll clarify.
What is the IA here?
I had to even a file.
There is an I.
What is the IA for?
It is for the interest on my amount as per the order of the Supreme Court, Lordship. I have given two Supreme Court orders regarding payment of interest whenever his salary is delayed.
Lordship, regarding that, that interest part has already been considered.
Interest in contempt we can't consider.
Lordship, these matters will be settled, then we'll talk about that.
No, because in contempt we don't have power to add or subtract to the order whatever is there. So we'll have to close it. In contempt we don't have that power. We can only go by the implementation of, we can only go for the implementation of the order or enforcement of the order. But we cannot add to the terms which are already there in the order.
In the order, Lordship, it was said that if he has got other complaints also, this he can agitate the petition.
No, you agitate in, but not in contempt. In contempt, we only enforce the order as it is. We can't add or subtract to that. So we are closing it. If you want to proceed, you can do it independently.
Petition.
But the petitioning person, as well as Mr. A. Chalian and counsel for the opposite party number. You are for whom?
I'll appear for in the party. So there's only one respondent, Lordship, in the IA.
Okay, you are not appearing for him.
Lordship, I'll appear for him.
Okay, for the opposite party. Next person. By filing this interlocutory application, the petitioning person is seeking a direction upon the respondent to pay 6% simple interest on the delayed salary and non-practicing allowance. Next person.
Lordship, in the order of this honorable court, I was asked to file a representation to the authorities, which I did. And the order said that they will have to give me a speaking order. And in that representation, I had mentioned about this interest part, whether they will pay or not.
Speaking order will.
They should say something regarding that.
Yes, so we'll place
Whether
that speaking
they will-
order also on the next date, my lord.
Whether they will pay or not, let them
No,
say
in
something.
contempt we can't enforce. We will clarify.
In the speaking order, Lordship. The order says speaking order has to be given.
Where is that? Which page?
Lordship, that's in the main contempt petition, Lordship.
Page number 17, Lordship.
Page number 17.
No, not 17.
Page number 17 of the contempt petition.
Of the contempt, not
Of
the
the
contempt, original.
No, 17 is a part of the order.
Here in the contempt petition, the page is numbered as 17.
Page number 17, Lordship. And annexer 2, Lordship. Page number 17, Lordship.
No, 17 is a direction. Where is the speaking order? They passed any speaking order? No.
Lordship, fourth last line from the bottom. Fourth last line from the bottom, Lordship, it said, it is provided that if such representation is filed by the petitioner within a period of 1 month from today, the competent authority shall dispose of such representation as early as possible, Lordship. That is what my learned friend is referring
No,
to.
that's okay. But
And the last
has
sentence,
any this speaking order passed?
The speaking order has not been passed regarding this representation.
In the first paragraph, last sentence, Lordship, it is needless to say that whatever speaking orders that should be passed shall be communicated to the petitioner in person. Last sentence.
So they have not done, and therefore you are in contempt.
Lordship, on the next date, we'll place the speaking order also.
Okay. So in the context of the prayer made by the petitioner in person, on the court is of the constitutional opinion that in a contempt proceeding, the court is required to enforce the order in respect of which contempt is alleged. Stop. It will not be within the jurisdiction of this court while in session of a contempt petition to add or subtract to the directions already issued in the order dated 8/3/2019, passed in WBC 5471 of 2014. Accordingly, the court is of the constitutional opinion that the prayer of the petitioner cannot be considered. So accordingly, the prayer made in this interlocutory application stands dismissed. In the main contempt petition, right? The standing counsel, the counsel for respondent number 1 and 2 shall inform the court about speaking order, if any, passed as per directions contained in the order dated 8/3/2019, passed in WBC 5471 of 2014. This one, sir. We'll give you a copy of this sanction order.
Item 45, fixed at 2 p.m.
Here, this petitioner was arrested on 22/12/2022, my lord. He is now about 19 months in jail. He once moved this court, my lord. And this court remanded the matter to, without rejecting the application, remanded the matter to annex 3 years. My kindly come. Page 14. After hearing the page 15, my lord.
Yes.
After hearing the land counsel for the parties and considering the above, this bill application of the petition namely filed in the Narcotic Bureau Crime case number so and so is closed, granting him liberty to move the concerned jurisdictional court for his regular bail and said Narcotic Control Bureau Crime case number so and so. Now that was on matter 21/6/2023, exactly a year ago. Now, he's before this court again. What is normally here in one Delhi quarter, my lord, 1B, the Narcotic Control Bureau got some information. It would be written from Annexure 1, my lord, page 11, that some drugs are stuck there. Then the people 1 who also deposed, there is nothing against me. In the cross, he could not say anything. But I'll show that. And on the basis of that information, my lord, this annexure 1, page 11, there was search, my lord. This person was not there. money rule and another person, 2 persons there. And while the seizing was going on, my lord, then Jitul Ali reached there. And on that suspicion, he was arrested. Although there was no possession in his, so far he was concerned, possession was with somebody. A railway quarter was also not his, it was allotted to some railway employees only. And he used to sometimes visit there. And ultimately, my lord, the seizure was also faulty, my lord, not in compliance with the section 50 and 52. What are the section 51, 52 provided, my lord? And also the section 40. 42, my lord, of course, he might be, my lord, authorized officer. That I cannot say who seized the item, who arrested the persons, may be authorized. It is not confirmed. But under section 50 and 52, my lord, there is procedure laid down. That doesn't seem to comply, my lord. From the cross-examination, the seizing officer, who is also PW1, deposed before the court, trial court. Only 2 witnesses have been so far examined in the case. Will also kindly come to section 50.
NDPS. NDPS.
Section 50. I'll also give your lordships we file the affidavit to the extent when any officer duly authorized under section 42 is about to search any person under the provision of section 41, section 42 or 43, he shall, if such person so requires, take such person without unnecessary delay to the nearest guest officer of any of the departments mentioned in section 42 or to the nearest requisition is made. The officer may detain the person until he can bring him before the guest officer or the magistrate referred to in subsection 1. The guest officer or the magistrate before whom any such person is brought shall, if he sees no reasonable ground to search for to discharge the person, but otherwise shall direct that such be made. So this is then matter subsection 5. When an officer duly authorized under section 42 has reason to believe that it is not possible to make the person to be searched to the nearest guest officer or magistrate without the possibility of a person to be searched, parting with possession of any narcotic drugs, parting with possession, because there is no possession found from me, or psychotropic substances, or controlled substance, or article or documents. Instead of taking such person to the nearest guest officer or magistrate, proceed to search the person provided under section 100 of the Code of Criminal Procedure. Now, my lord, seizure list, whether independent witness, as it appears from his cross-examination, he could not, he didn't search for any independent witness. So, under section of the CRPC requires 2 independent persons to be witness to the seizure. That is not there. And my lord, section 52A,
Yes.
Yes, my lord. Now, one decide between file, my lord, where I have annexed the evidence of the PW1, that is, my lord, the seizing officer and arresting officer Kaushik Sarkar. In his cross examination, my lord, there is annex.
petition 2023 का है ये एग्जामिनेशन पूरा दिसंबर 23
There's a lot of my lord. You will kindly come to page number 2 of the cross examination.
Yes.
When I seized when the seizure procedure was going on, then Jitul Ali arrived on the spot. The seizing officer has applied the procedure as required under section 41-42 of the NDPS Act. It is not a fact that without ascertaining the fact, I acted on the belief of the house belonging to Jitul Ali. I have not visited the next door quarter of B71 in respect of searching the independent witnesses, and also has not went there to ascertain who is the actual owner of the quarter number B71. As I was certain that the quarter belonged to Jitul Ali. It is not a fact that I have not forwarded the original exhibit 1 of to my superior. It is not a fact that I have links with the informer and manufactured exhibit P1 in order to bring false charges against the person accused persons for vested interest. There were 3 persons, my lord, accused. It is not a fact that said house did not belong to Jitul Ali. That Manirul Islam is not the caretaker house. Actually, it was seized from the Manirul Islam. He was in the quarter with the drugs. It is not a fact that seizing Innova vehicle did not belong to Jitul Ali. It is not a fact that Manirul Islam belongs to South Salmara on the date of occurrence of Sansu. And this is LIB. It is not a fact that I have deposed falsely in Sansu. So, Mother, admittedly, he didn't ascertain the independent witness also. Mother, he did not find in my possession. It was in the possession of the Manirul Islam who was at the house with the drugs. There is one thing, my lord. It is a serious lapse, my lord. Ultimately, even in the trial, it would fail. And my lord, he has been in jail, my lord, for about 19 months. Since 22/12/2022.
Yes.
And my lord, listen. Small, my lord, small order of the Honorable Supreme Court. I am producing your lawsuits. These are also NDPS Act under section 21C. One is, and the other is my lord,
Yes.
So, my lord, I humbly pray, my lord, on the basis of the fact and the admitted position of the seizing officer who prepared the exhibit 1 and also till today only 2 witnesses were examined. So, my lord, our court, Supreme Court also has said about 1 year, 6 months since the date of arrest. But he has already more than 1 year, 6 months he has spent in jail. So earlier also the bail was not rejected because the court was of the opinion that he should get a chance once again to move the special court. So I humbly pray, my lord, if there are serious lapses, my lord, in seizure, in arrest and search. So, my lord, you will cooperate, my lord, and also already the investigation is complete, my lord. Now trial is going on, he will cooperate. And my lord, one interesting factor was there. Without the FSL report, my lord, charge sheet was submitted. Without the FSL report, my lord, charge sheet was submitted. This also perhaps not desirable in a serious case of involvement of in the NDPS Act.
Yes.
Lordship, in this case,
Yeah.
final complaint was filed on 14/6/2023.
Just a moment. Final complaint.
Filed on 14/6/2023. Against 3 accused persons, petitioner, one Moinul Islam and one Akitur Rahman. And charges were framed on 6/11/2023.
Charges framed on
6/11/2023. Out of 11 witnesses, 2 have been examined till date, and next date is fixed on tomorrow also for examination of further witnesses.
Yes. What is the stand about this when the seizure and the arrest is not proper?
Lordship, that is a matter of trial, Lordship. And as per our information, Lordship, all procedure has been followed while making search and seizure. And Lordship, interestingly, in the bail application, except that FSL was not filed along with the complaint, no averment is made with regard to non-compliance of any of the provisional plan. And interestingly, this application was filed in April 2023. Till date, it was pending. And Lordship, ordership will reflect why it has been delayed it was pending for more than 1 year. In the meantime, Lordship is pleased to occasion to deal with one bail application of co-accused. Lordship, go to paragraph 7 to 11. The role of the present petitioner, Lordship, that has been reflected in the order of Atikur Rahman. Is the name of the present petitioner is Jitul Ali. Paragraph 7 onward, Lordship.
Okay.
And let's say with respect to delay in trial, let's say this is a heinous crime. And in heinous crime, let's say the second judgment, let's say put in Gurvinder Singh, Supreme Court says that in case of heinous crime, delay in trial cannot be a ground for granting bail. That's been reflected.
Which case? This Ravindra Ray.
Yes, let's say in this case, let's say paragraph 7 to 7 and onward, all the authorities of the Supreme Court has been taken into consideration. And Lordship in the bail order of co-accused, Lordship has taken into consideration all the judgment filed by the Honorable Supreme Court.
Okay, let me consider pass on this.
Under the one accused will be bail application rejected by lordships to the earlier point of time, and the position the drugs are found in his position. Manirul Islam in his position drugs were.
I'm not getting it. Please repeat again.
The Manirul Islam who was in the house, the drugs were found in his position. Admittedly in the cross, not in my position.
Let me consider this a voluminous record received.
Yes, my lord. So, my lord, he has already spent 19 months. Generally, Supreme Court has also one, two cases, and this court also, in number of cases, my lord, after 18 months, they are released.
Much of them.
Always, my lord.
Time being item 57 with 58.
May I please the lawsuit? My lord, item number 58 may be taken fast. My lord.
Yes.
My lord, I have challenged the departmental proceeding on two grounds, my lord. The number one is that, my lord, the authority who has already come to the conclusion that I'm guilty, my lord, is functioning as a disciplinary authority, my lord. In this regard, my lord, I have annexed one document, Annex 6, page 56.
Page
56.
of which writ petition?
Item number 58.
58.
It is issued by the Railway Board.
56.
56, Annex 6.
Yes.
May I read?
Which paragraph?
My lord, it's a letter issued by the Railway Department, my lord. Subject was authority who has acted as a member of
56
chairman.
is document, page 5 of some document.
Case.
Yes, Lordship. 56 is a continuation page.
Item number 58.
Yes.
Page number 56.
Uh,
Wait, what is it? This is article of charges.
Page 58, item
The
58 you want
last
us to
page,
take?
the last page, my lord.
You want us to take 57 or 58? Which item you want to take?
141. 58, my lord.
Give the writ petition number.
141.
141.
First of all, no?
56.
56.
Yes.
My lord, the subject is authority who has acted as a member of chairman of the fact-finding inquiry should not act as a disciplinary authority. A point has been raised whether an authority who has functioned as a member or chairman of the fact-finding accident inquiry committee can function as a disciplinary authority for the purpose of considering the explanation to the charge sheet, ordering a departmental inquiry, holding a departmental inquiry itself, or imposing the penalty within its own powers. The matter has been considered in consultation with the Ministry of Law and has been held that if an officer, while functioning as a chairman or member of the fact-finding committee, has already come to a conclusion and made recommendation that a particular railway servant is guilty, it would be difficult to expect him to approach the case with an open mind. Even more, the railway servant would apprehend that the officer, having expressed an earlier opinion, would not, as a disciplinary authority, depart of his own earlier findings, and such he may have a reasonable apprehension that he would not put a full hearing. It would therefore not be correct for an authority who has already come to a conclusion regarding the guilt of an employee, a chairman or member of a fact-finding committee, to function as a disciplinary authority where there is a likelihood of major penalties being imposed.
Yes.
Now, Your Lordship, kindly say Annex 2, page 29.
Yes.
It is show cause notice.
Yes.
On the basis of the fact-finding report of Sri Anupam Chakraborty,
the then ASC RPFTS case, file number so. So the fact finding officer was ASC. Now your lordship kindly see annexure 3, case 36. The same authority member has issued this memorandum.
Page number
37, your lordship can see 37.
37.
7. It has been issued by Assistant Secretary Commissioner RPF NF Railway. Is acting as a disciplinary authority.
No, we don't find that. We don't find that projection to be correct. The as per page 29, the person involved is Anupam Chakravarti.
No. Person involved is
Fact finding report of Anupam Chakravarti.
Fact finding report on.
Correct. Now the Assistant Security Commissioner who is issuing the notice, from his signature we make out the name of SK Swain.
Well, the person is different. The authority is the same.
No, that can't be.
Person is different, but the authority is the same.
That can't
Same
be.
authority.
You can't stop the entire what do you call country from functioning because of that.
Yellowshi kindly see.
In a railway, it is the officer who is the fact finding officer, and he is not the disciplinary authority.
Because
Somebody else is in that post and he is now taking up. So he will not be.
But holding the same post, Miller. AC.
So what?
Because
it doesn't mean that no ASC can take up the matter.
They are acting as a fact finding inquiry officer, and the same authority is acting as a disciplinary authority. That's why this letter has been issued by the.
No. If it is the same person, it's not the same person.
It's not the same person, but the authority is the same.
No, we can't accept that. That is a contention we can't accept.
Well, she can't.
But you have challenged the disciplinary proceedings, right?
Yes.
You're issuing a notice.
In this case, already notice has been issued.
Already final
there is
order
an
passed,
interim order.
lordship. The first order there, I have already filed my affidavit. During pendency, the no stay was there. So now removal of service or punishment was awarded.
Okay.
Against that, he is in the secondary petition.
So we're issuing notice there also.
Lordship.
In this case, already notice has been issued.
Here I have
Item
filed my
58,
affidavit.
and there is an interim order.
Don't give my number. Writ petition 141.
141.
141 is okay. But this would become infructuous then.
Yes, lordship.
141 would become infructuous. If after that you have been removed from service and that has been assailed.
Yes, the second petition I have challenged on two grounds.
That will
One
be-
is violation of natural justice.
That will be
Another, the
that will
person
be okay, but this
who has been acting as the inquiry officer is not competent.
but the first writ petition has to be closed. 141.
And in 141 Miller, there's one more ground, Miller. The person who has been appointed as an inquiry officer, he is lower than the rank than the fact finding officer. It is also not.
No, but everything gets merged into the order of dismissal.
Miller.
Everything gets merged into the order of dismissal.
No, there is the order, Miller. It will be subject to the outcome of the litigation.
But please tell us that order, what weight would it carry after the order of removal? After the order of removal, it is the only order of removal you can challenge. In that, you can make a collateral challenge to the manner in which the inquiry took place. But can the first writ petition be otherwise adjudicatable? We ask you the question.
Because when there is an order, well, it will be subject to the outcome. Whether any order is passed.
No, you forget the order.
Yes.
But please tell us, we are asking you a question as an officer of the court. Once the what you call disciplinary authority has passed an order of removal you from service.
Yes, sir.
Now, in connection with that, you can always examine the manner in which the proceedings took place.
Yes, my lord.
So how would the first writ petition be maintainable? It will be infructuous exercise we'll be spending our time on. Because at best we can only permit you if you have not assailed the manner in which the proceedings was conducted. We can only give you liberty here to take that plea.
In 1957.
If you want, we can give you that liberty that you can bring on record the challenge of this. But the first writ petition for all other practical purposes, you see the prayer, come to the prayer in this writ petition 141.
Yes, my lord.
Quashing the memorandum of charges, that cannot be quashed because it's already that has been spent over because of the fact that the order of punishment has been given.
Yes, my lord. Yes.
So this prayer can't be allowed now.
Yes, my lord.
So at best, we can permit you to amend your petition. There is a ground to,
and
on which the earlier petition is there. Well, Mr. I. Rafiq, Learned Counsel for the, this is in WBC 2709. Also, Ms. B. Sharma on HCGC appearing for the respondents. Next, the termination of service of the petitioner by order dated 10/1/2024. What is this 10/1/2024 then?
My lord, in this case, I have been awarded the punishment of dismissal, expurgated.
It's not a prayer in your writ petition. In your uh, in the matter of you are referring to that 10/1/2024, but in your prayer, this is not the prayer.
In 2024, my lord, I have paid to was the ex parte inquiry report, my lord, and the impugn speaking order.
As I said, the ex parte inquiry report dated 17/2/2024, and the speaking order dated 2/3/2024. Which is passed by the disciplinary authority within bracket respond number 7. Issue notice including notice on the issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the net CEC in course of the day. Next paragraph. In connection with WPC 141 of 2024, filed by the petitioner, the court is of the considered opinion that after the order passed for removal of service of the petitioner, the said petition has been rendered infructuous. The court grants liberty to the petitioner to suitably amend the present writ petition to incorporate any new ground he wants to, on which he wants to challenge the departmental proceedings. Next para. List after 4 weeks.
Lordship. One more line, Lordship. There is an appellate provision also, but that was not availed, Lordship. The order itself is also.
Once he says that the principle of unjust justice is not followed, we can still examine that. Okay, next one. The learned CGC has submitted that against the orders passed for removal of service, appeal provision is provided for in the concerned service goods, and the alternative remedy has not been availed by the petitioner. The learned counsel for the petitioner shall address the court on the availability of alternative remedy on the next date of listing.
Item 48 for orders.
Yes, what are your instructions?
Lord, all the papers, my lord, have been submitted to the finance department. It is now, my lord, pending before the finance department, my lord. We are informed that very soon, my lord, it will be sanctioned. The petitioners are, my lord, apparently entitled, my lord, for grant of minimum pay scale, my lord, in terms of upendas.
Okay. So we take up after 4 weeks. In that time, within that time, I think.
Yes, Lord.
You will.
This is what the department has also asked.
Okay, Mr. Chaudhary, we are giving them some time.
They will get it, my lord. Apparently, they will get it, my lord. There's
okay.
no point of residing from here.
Mr. HMR Chaudhary, learned counsel for the petitioner is present. Mr. Borpujari, learned counsel for respondent number 1, and Mr. H. Alia, learned counsel for respondent number 3. Case for an is granted 4 weeks time to obtain updated instructions as regards the status of the implementation of the order dated.
That is order dated 7/4/2022.
7/4/2022, passed by
in
this
the-
court in WPC 1217 of 2022.
My lord.
Okay, this after 4 weeks.
My lord, I have another prayer, my lord, in respect of item number 33, my lord. That matter may be taken after vacation, my lord.
Only 33.
33, my lord.
Okay, just note it. 33 after vacation.
Obliged.
Obliged.
Mr. Borpujari, there are 2 matters here in both same orders.
My lord, I am checking it, my lord.
Oh, achha. So in the first petition, it will be Mr. Hierarchy, counsel for the petitioner, and this B. Sharma will sees for this for the respondents. As far as the departmental proceeding has already culminated in the passing of the order of removal of service of the petitioner. Court is of the considered opinion that this matter has become infructuous. So accordingly, this petition stands closed. In view of the subsequent development and subsequent challenge made by WPC number, so and so. Okay. No, this was the previous order. I forgot to dictate the order in the
I was
previous
checking it,
order
my
plan.
lord.
I had forgotten to dictate that order.
Obliged.
Item 49.
Item 49 with item 50.
Investor, applicant file and interlocutor application for extension of the date for paper publication.
Pardon me?
My lord, kindly see the order dated, my lord. T4 2024, page 7, my lord. My lord, 11%, my lord, page 12, my lord, para 3. Your lordship was directed to paper publication on 24/2024. It was
Your name?
K. Kolita, madam.
Mr. K. Kalital and counsel for the applicant. Stop. By an order dated 3/4/2024 passed by this court in IS Civil 868 of 2022. Time was granted for publication of notice in substituted manner in one English and one Assamese daily. Full stop. Next, the learned counsel for the petitioner has submitted that there was a communication gap and he could not communicate the order to the applicant, and therefore prays for further extension of time for making the paper publication. Next, the period is considered and allowed. Full stop. How much time you need to?
1 month from today.
1 month.
Yes, madam.
The learned counsel for the petitioner seeks 1 month's time to make the newspaper publication. Next, and the steps be taken within 2 days. Next, the publication of notice on the respondent numbers 11, 12, and 13 in a substituted manner by publishing it in one English and one Assamese daily, having wide circulation at Guwahati within 2 days. Published within 31/7/2024. The date of appearance shall be indicated in the notice as (19/8/2024). The petitioner, the applicant shall file the affidavit of service along with and produce the copies of original newspapers where the notice was published. Next, for a list on 19/8/2024. Okay.
Item 51.
May I please, your lordship? Lordship, this intervening application my lord for substitution of petition number 5, my lord.
5 has died.
Legal heir.
Okay. Your name?
HP New, madam.
HP?
New.
Mr. HP New, learning counsel for the applicant. This interlocutory application has been filed for substitution of petitioner number 5 in the connected writ petition with his wife
Anita.
Srimati Anita Baishya, wife of late Kanak Baishya.
Paragraph 4, my lord.
So with his the learned counsel for the applicant has submitted that the rate petition number 5 had died on 8/6/2023. Full stop. Forest will be there. Mr. K. Pathak was here. KP Pathak. Okay, Mr. KP Pathak, learned standing counsel for the Forest Department. For principal accountant, you are there. For finance, Mr. R. Propujari, learned standing counsel for the finance department. Mr. S.K. Medi, learned standing counsel for the accountant general. And this pension will be appearing. Mr. C. Hazarika, learned government advocate. For respondent number 5 and 6 are present. Next paragraph. In view of the death of the petition number 5 in the connected rate petition, this interlocutory application stands allowed, and the applicant herein is permitted to be substituted as legal representative of the deceased petitioner number 5. In the connected WBC 3959 of 2023. So this application stands allowed. In the rate petition, you write heard so petitioner and respondents. In view of the order passed today in IA Civil 1330 of 2024, the substitution of the applicant is allowed in respect of the deceased petitioner number 5. Stop the learned counsel for the petitioner shall provide amended cost title to the AOJ civil rule pending section, who upon receipt of the same shall make it a part of record and also cause correction in the central registry. The petition will be coming up for admission. This is the matter of the admission problem.
Um, 52.
May it please your lordship, this IA has been filed for correction of the post title filed in this petition. Paragraph 3 of this application may kindly be perused, page number 5.
Okay. Your name?
MS S. Dasgupta.
Ms. S. Dasgupta, and counsel for the applicant. Whether you are appearing?
Yes, Lordship, I'm appearing for 1, 2, 4, 5, and 6, Lordship.
Miss,
5, 6, 7, and 8.
I forgot your name.
MM Kushaki.
Yes, MM Pataki, learned counsel for the respondent numbers 1,
1, 2, 5, 4, 5, 6, 7, and 8.
8. And Mr. Opposite and standing counsel for the finance department representing respondent 3. Next, filing this interlocutory application, the applicant who is the writ petitioner in the connected writ petition has prayed for amending the name and designation of respondent number 1 and 2 It's not. The prayer is allowed. This one is the application stands disposed of. And be connected with petition, you say. First and so. In view of order passed today in the connected WBC, IS Civil 1598 of 2024. The amendment of post title of in respect of the respondent 1 and 2 is allowed. The learned counsel for the petition shall provide a freshly typed cost title to be put to the UJ civil pending section. On receipt of the same, shall make the same as a part of the record and shall also cause correction in the central registry. Full stop. After corrections are made, this is the matter after ensuing some action in the admission column.
$53.
Obliged, Lordship.
Me pleasure, Lordship. Lordship, in this measure, any application for the substituting the name of the respondent number 2 and 3, my lord. My lord, it should be respondent number 6 and 7 instead of 2 and 3, my lord. That is case number 3, my lord. Respondent number 6, my lord, the secretary to the Court of Custom Public or
I'm not
Department.
able to follow you. You want to substitute name of respondent number 2 and 3.
2 and 3, yes, my lord.
The opposite party is 6 and 7.
6 and 7.
Okay. Your name?
R.I. Bhuya on behalf of NSM.
Your name?
R.I. Bhuya.
R.R. Bhuya, the counsel appearing on behalf of Mr. N. Islam, counsel for the applicant. Also heard Mr. R. Dhorlan, standing counsel for the PWD. Let's follow. This respondent number 5 is your authority, Mr. Dhor? Executive Engineer, Sibsagar Rural Division. PWD has such a division?
My lord, respondent number 5, he has to no, department is indicated, my lord. That is the problem. Respondent number for executive engineer, Sibsagar Rural Division.
How many times will amend your petition? Now, number 5 is not there.
5, my lord, no department is indicated. Executive engineer of which department?
You visit that we just adjourn it. On the prayer made by counsel for the applicant, the matter stands adjourned today.
If it correct, we will do it.
Sardhar, standing counsel for the PWD is present. Please start answering summer vacation. Why it is so difficult to read a writ petition?
54.
Lordship, as per Lordship's order, Lordship, we have filed PDP towards completion of dusty service.
Has it come? It's not come.
Lordship, come. I have checked also record.
Oh, acha. वो कोर्ट में बाबू को कहते हैं मैंने केस मैंने
The page 33 in respect of the respondent number 9 lordship and page 38 the respondent 8. Lordship, in the meantime,
I appear for respondent number 227.
Lordship, in the meantime, the days for the consideration of the interim plan. Lordship, during the pendency of the requisition, as per Lordship's earlier order, the respondent has disposed of the requisition submitted by the petitioner, wherein they have admitted that they are coming from the Tinsukia. They are the private respondents were transferred from the Tinsukia district. They are only contents of
No, FCI 227. My lord. No, my lord, we have been instructed to appear by the district office. We have filed local authority yesterday. We are yet to receive the copy of the writ petition, my lord, from the office.
we have already served 4 copies to the earlier council.
Let it come after vacation, my lord.
We have already an acceptance notice also submitted on 15/6.
Yeah, understand. Yes, my lord.
Then
Because Mr. Chakravarti, they are now pressing the prayer for interim relief. That the petitioners are trying to show that in your promotional order,
Yes.
you maintain the FSD wise seniority list. So there are different seniority lists for different persons coming from different FSDs. And therefore, the petitioner is from, you are from
I am for the original
Hojai.
Hojai.
He
And the
is
private
from
is for
Hojai.
Tinsukia.
And Tinsukia people have been placed in before him, and he has not been promoted. So
And lots
the
of
petitioner is saying that you can't allow persons who are from different establishments,
Different depot.
different depot, in a common what you call seniority list. They are all treated separately.
And lots of if lots of peruse the order dated 13/6, whereby the requisition was disposed of, therein they have admitted that they are from the Tinsukia region.
Man will take it up
They are from the
immediately after
Tinsukia
vacation. Man, I am not having
And
the copy of
they
the
are on
petition.
only ground that no objection was received from the any corner, lordship. But whether from the question of if presuming that
No, you are right. Yeah, right.
because there is a guidelines, lordship. They cannot violate the guidelines.
Man will take it up on 19th. Man.
As indicated in the previous order, dated 5/6/2024, it is reiterated that the promotion made to respondent number 8 and 9 to the post of Mandal at FSD Hojai shall be subject to further orders that may be passed on the next date. Post of the next date, as the learned standing counsel for the FCI has prayed for deferring the hearing on the prayer for interim relief. Full stop. List on 22/7/2024.
For consideration of interim order.
Okay.
Immediate time.
I have indicated.
Hello.
Item 15 to 20 for admission.
Lordship, heard the matter. My learned plan is to reply, my lord, to what.
Mr. Dasgupta will defer it for after vacation because they will be fresh in my mind.
All right.
Otherwise, I will be having a tendency to forget in this.
And we have
vacation.
given the list of deaths also prepared. Let the matter be kept as part, and on the last occasion it was listed with another judge.
Okay.
No, there is an order.
There is an order, of course.
Okay. Although Mr. A. Dasgupta and senior counsel, assisted by Ms. B. Das, counsel for the petitioners is present. Petition, as well as Mr. S.K. Roy, Mr. P.K. Roy, and a senior counsel assisted by Mr. S.K. Chakravarti, counsel for the respondents are present. Yes, but although this is a part-time matter, but as the
Due to paucity of time, let me clear.
no, let us be honest about it, because of the ensuing summer vacation, the court is not inclined to take up the voluminous hearing.
Yes.
And therefore, the hearing is deferred. Next for a list on 23/7/2024 as a part-time matter. It will not, I will not feel good. Because the adjournment I am taking, this time I am taking an adjournment. Okay. Mr. Dasgupta, the difficulty is that for some assignment, I have to read a 900-page booklet within these 2 days.
900 page.
I have to complete reading, and there's a program on Sunday for that.
Oh, yes, that is a good decision. It is good for us also.
That I read.
It is good for us also. Then. Blessed.
So you have doubt that I read. You have a doubt that I read.
No, I mean, people lordship is 900 page. Again, our case.
So that's why you are joining this matter. Really, I don't have the energy today. Yes, item
21.
21.
My lord, the declaration was sought for the Honorable Justice.
Yes, has it come?
Yes, perhaps. Yes.
It is there.
It is there, my lord.
It is there, madam. I've seen it.
Okay. Okay. So we appoint on this. Heard Mr. R. Hussain, counsel for the petitioner. Also heard Mr. S. K. Mehdi, learned CGC, appearing for the respondents. Next, by order dated 5/6/2024,
5/6/2024.
by an elaborate discussion, the court was inclined to propose the name of Honorable Mr. Justice Achintya Malla Bujabarua, former judge of this court, as the sole arbitrator to arbitrate all the dispute between the parties arising out of or in connection with the contract agreement dated 28/2017. Stop. Pursuant to the said order dated 5/6/2024, the petitioner has taken steps upon the Honorable proposed arbitrator for disclosure as required under Section 11 within bracket 8 of the Arbitration and Conciliation Act, 1996. Stop. The court is in receipt of a disclosure statement by the Honorable proposed arbitrator dated 24/6/2024, wherein it is indicated that he has no past or present relationship or any interest with any of the parties or in relation to the subject matter in dispute, whether financial, business, or professional, or any other kind. Full stop. It is also disclosed that as of date, no circumstances is noticed which may affect the ability to devote sufficient time to the arbitration, nor any circumstances is noticed to finish the entire arbitration within 12 months. Full stop. In view of the said disclosure statement, which is accepted, this arbitration decision stands allowed by appointing Honorable Mr. Justice Achintya Malla Bujabarua, former judge of this court, to act as the sole arbitrator. As per the to arbitrate all the dispute between the parties arising out of or in connection with the contract agreement dated 27/2018. Next paragraph. The parties shall appear before the honorable arbitrator on what date?
After vacation month.
On or before 26, on 26/7/2024.
26.
26/7?
20 minus 22
22.
20 20.
20. Okay, 20/2020. 2024. And wait for the instructions from the for the instructions from the sole arbitrator. Yes.
Matter is disposal.
This is disposal.
Item 22. Item 22.
I please your lordship.
Just a moment. Just a moment. Yes, you have the information.
No, my lord, that cadre strength, my lord. We have written a communication, my lord. We haven't received that cadre strength yet, my lord. We will need further little time, my lord, for that, my lord. Not within 5% quota.
But it can't be that the government is not aware how much is the staff strength.
That cadre strength, my lord, it comes from the division. It comes from the usual division, my lord. That is.
No, there must be some central way to monitor it. Ultimately, you are paying salary to the staff. You can't say that we don't know how many persons are there in grade 4.
If you go by the pleading, my lord, the case of the petitioner, there are 16 numbers of vacancies, my lord. Even if there is 16, my lord, we cannot carve out one from there. Because 5%, for 5%, it has to be 20 posts.
No. 5% is the quota of the cadre strength. If your cadre strength is 100, then 5% is for compassionate appointment. That would be how much?
5.
That would be 5.
If it is
so whether 5 people are there in man in position only, you have to get that only. It doesn't take so much of time. Within a shorter period, you do what you call voter list updation. When it comes to Lok Sabha elections. If you go even house to house, you'll be able to do it faster. Ultimately, he has to give because he is said in the affidavit in opposition. Who is responsible for?
Respondent number 4 is my lord.
4 is Deputy Secretary of Government of PWD.
PW Deputy Secretary, my lord.
Who is Deputy Secretary to the Government of Assam, PWD?
17. In para 3, we have stated, my lord, not within 5% quota.
So therefore, It is a difficult thing that. You get the advantage of this summer vacation. You tell us within 17th of July.
Ma'am.
Mr. M. Roy, then counsel for the petitioner is present. Mr. R. Dhorlan, standing counsel for PWD. Grace for him is granted. 3 weeks time to file affidavit in terms of order dated 15/5/2024. Mr. C.S. Hazarika, government advocate for respondent number 1, 2, and 5 is also present. List on 17/7/2024.
Twenty-three.
Because if you don't have the staff strength, anybody will come in and then claim that no, I am in your service role, you make me payment. How will you know that he is not in service? Item 23. My lord. Yes.
The petitioners claim this ACPS benefit. It was denied. That is why writ petition on the space 34 is the scheme, my lord. He has completed 37 years of service. As per scheme, my lord, after 10 years, 1 promotion, and after 24.
Yes, sir, affidavit is not there.
Not
So
quite
we,
valid.
so we accept his case and then we direct you to make that exercise. Who is the person who will give that, who will make that calculation?
My lord, this has come up, my lord, after a long time, my lord. My lord,
Yes.
let this matter come after vacation, my lord. In the meantime, we'll file our affidavit, my lord.
You filed, you are sure?
Sure, my lord. My lord.
You have paper, pen, ink, everything. You have.
That instruction is, my lord, still evident. That's the problem, my lord.
No, instructions, so okay, you'll get it. But do you have paper, pen, ink, everything? How will you prepare your affidavit if you don't have paper, ink? Paper, pen, ink, if you don't have, how will you prepare it?
My lord, we usually do it in a computer and printer.
You will do it, okay. Mr. M.J. Barua, counsel for the petitioner is present. So in this writ petition, notice was issued on 14/3/2022, but till date, no affidavit in opposition has been filed. Stop. On the prayer made by Mr. R. Thorlan, standing counsel for the PWD, the last opportunity is granted to the respondents to file the affidavit in opposition. During which the matter would be heard on the basis of materials available on record. In view of the fact that the petitioner is claiming assured career progression scheme benefit by claiming at least 2 financial upgradation.
1, my lord, 1 promotion given, second promotion was due after 24
Okay,
years.
one financial upgradation.
Yes.
Okay, 1 financial upgradation during his 37 years career.
Yes.
This after seeing some of the different.
Unless.
24.
24.
Yes,
My lord,
file your affidavit. What is your stand?
My lord, APSC has filed their affidavit, my lord. I have received an instruction, my lord. I need to file an affidavit, my lord.
No, that you took an undertaking on the last occasion. 14/6/2024, we have recorded your undertaking.
My lord, this is the instruction has come little late, my lord. But without that, this affidavit, my lord, it will be little difficult, my lord.
How much time?
My lord, I will file, my lord, during the vacation of only, my lord, during vacation code even. Someday, my lord, I will just file it. So that it can come up, my lord, just on reopening or the next day of the reopening, my lord.
It will give nothing.
What is your instructions on this cabinet on your on this cabinet decision of 31/3/2020? What is your instruction?
My lord, instruction I have, my lord, but if I go with this APSC, my lord, there is little contradiction. That is what I wanted to know. Cabinet decision is up to 44 years. If I go by this petition, my lord, that is what, my lord, and he was 45.
Annexure F, page number 43.
44 years, 6 months. So that is where, my lord, that part.
No, because if a cabinet has taken decision to relax
up,
Yes,
up,
my lord.
up to 44.
Annexure F 43, it is clear that the public or grievance were appointed.
My lord, that is page 43. Relaxation of upper age limit up to 44 years.
44 years for
As on
And-
1/1/19.
44 years.
Apply for the post of junior engineer on direct recruitment under public work
No,
department.
what is the date of advertisement? Employment advertisement is what date?
Advertisement?
Advertisement dated, my lord,
19?
19/11/2019, Annexure C, my lord.
31.
19/11/2019.
19. For junior engineer, page 32/33.
Just a moment. So on that this 19/11/2019, what was her age?
Lordship, on 1/1/2019, the age of petitioner number 2 was 44 years, 6 months, 16 days, Lordship.
44 years, 6 months.
16 days. And petitioner.
Just a moment. 44 year, 6 months, 16 days.
Lordship.
15 days.
And petitioner number 1,
49 years, 10 months.
49 years.
10 months.
10 months.
Yes, then how can you be saved?
My lord, in a cabinet decision, page number 43, it was specifically stated that as a special case. Last line. my lord. As a special case. Moreover, petitioner 1 and 2 both belongs to SC and ST category.
But that doesn't have a special category in this on the cabinet decision. Because in this page, if you are making me read page 43, 43 says 44 years as on 1/1/2019.
Yes.
So there's no other scope for further extension of the period of this age, relaxation of age.
Relaxation of upper age limit up
My
to
lord is
4 years.
exactly correct, my lord. If you read the last paragraph even, my lord, The last line.
Last line, my lord.
As per the honorable cabinet approval for relaxation of upper age limit, a special case. That is
Pretty-
what, my lord, 44 years is a special case, my lord. 44 years has been, my lord.
For nine candidates, special cases.
That is,
They belong to unreserved and reserved category.
No, you see, we have to go by the prescription of the government.
Specifically,
How
as
can
a
we-
special case,
how-
my
how-
lord.
No, that's okay. But even for special case, they say, they give a specific date, 1/1/2019, 44 years. We give them time, let them file an affidavit, because we don't find merit in the matter. All sides are represented. Mr. R. Dhar, learned standing counsel for PWD, response is granted 2 weeks' time to file affidavit in opposition in the matter. So, list of ensuing summer vacation. You file it, don't delay.
no,
Mr.
my lord,
Dhar.
I'll tell you.
Yeah, please date, fix a date, my lord.
Not right now, because you make a mention after the vacation. We don't have a what you call a fixed date in our calendar right now.
Item 26 with production list item 1.
Lordship, in this case, one IA has been filed for this amendment of the writ petition by incorporating certain new facts. So can it be taken after vacation? In the meantime, a learned friend will be in a position to obtain the necessary instruction. The IA for amendment of the writ petition, this penalty, this order of penalty, the appeal has been preferred against the order of penalty, so that has been rejected. So I just want to incorporate that aspect of the matter.
Okay. This production list. You said, Mr. S. P. Chaudhary, counsel for the applicant, as well as Mr. D. Upamanyan, and standing counsel for the health department. Next product. You should notice on this interrogatory application, by which the applicant has paid for amendment of the conducted writ petition. Stop. List along with the connected WPC 8447 of 2022 after the ensuing vacation.
After vacation, Lordship.
Lordship, extra copies, Lordship.
Okay.
Yes.
Highly obvious.
27.
Right, your Lordship.
A PDCL was supposed to file affidavit in opposition. On the last occasion, they made a submission that
Yes, my lord, we have received the instructions. Further, 3 weeks' time may be granted to file our affidavit, ma'am.
same submission was made on the last occasion.
Earlier, it was. The instruction was not clear that why the others were not included.
No, but on the last occasion, you made a statement that Mr. Chaudhary was there.
Yes, ma'am.
He said that he will obtain instructions.
Yes, my lord. Instruction has been received. Now we want 3 more weeks to file our affidavit.
Okay. Mr. Olaskar, counsel for the petitioner, is present. On the prayer made by standing counsel for the APDCL, 2 weeks' time is granted to file affidavit in opposition in the matter. So list after ensuing summer vacation.
Date may be given.
I'm not fixing a date. You make a mention after the we open.
29.
What is a covered case, lordship? Or a Departmental Tiwari lordship?
Lordship, Seniority leg in another court. Kindly pass over for time being.
Seniority is in leg in another court. Kindly pass over for time being.
No, because we don't have time today. Just after answering some vacation, is paid for by run transfer of the petition. Mr. A. Chakravarti, learned government advocate is present. Okay.
RT.
In this matter, my lord, we have filed an affidavit, my lord. Some vital point was left out, my lord. File additional affidavit, my lord. After vacation, my lord, in the meantime, we will file affidavit. Now, we have received the instruction from the secretary. Some vital point was left out. That's why we will file an additional affidavit, my lord.
Last occasion, my lord, they're supposed to produce the record, my lord. Last occasion, my lord, they're supposed to produce the record, my lord.
So there is no order of that nature in the last order.
Yes. Let them file affidavit, my lord. If required, my lord, we will file a reply, my lord. Additional replies.
But what about provisional pension? That can be always processed and released.
Pension he is getting.
This is not for pension, my lord. This is for the MSCPS. There's an increment, my lord. Upgradation of the pay, my lord. Under the scheme of MSCPS, my lord. My lord, I have completed my continuous service in the same post for last 14 years, my lord, but I have not been giving the benefit of upgradation of pay or promotion, my lord. And lastly, my lord, on 31st of December 2023, my lord, I have retired from my service, my lord, for due to my superannuation.
Okay. No, but why this is order here? 89, I think on your pair, this order was here. Pendency of the writ petition shall not be a bar for the respondent authorities to process and forward the pension proposal of the petitioner.
Now he is getting pension.
Already, my lord,
You're getting
pension has been paid, my lord.
That part has been.
That part has been over, my lord, only.
Both sides are represented on the prayer made by Mr. T.C. Sudhir and additional senior government advocate.
Normal as a standing
Oh,
counsel, Seva.
standing counsel for Seba.
Okay, 31, 33.
2 weeks for the time is granted to file additional affidavit. As paid for 2 weeks time is granted to file additional affidavit. Just after answering some revision.
RT1.
Is it possible, my lord, that may be fixed, my lord?
Fixing a rate because we are at a wit's end right now.
Obliged.
31, we have already filed affidavit.
May I please, your lordship, in respect of 31 and 32, lordship, I may be allowed to file our affidavit in reply, lordship.
Okay. On the prayer made by both of the representative on the prayer made by counsel for the petitioner, 3 weeks time to file affidavit in reply in the matter. P.C. Sudhir and additional senior government advocate is present.
Much obliged.
Two. 34.
No, 32.
Obliged.
Same matter, lordship. 31, 32, lordship.
31, 32
Same.
same. Okay. 34.
34.
May it please your lordship. Lordship, the matter pertains to compassionate appointment, lordship. Lordship, the father of the petitioner died in harness on 30th of July 2016. He was working as a grade 4 employee under the Chandrapur Circle Office, lordship. An application was submitted.
Ms. Baba, in these 16 matters, we are not entertaining, we are dismissing it.
Lordship, several representations were submitted time to time, lordship. Our only prayer is that, lordship, so that we get the only grievance is that, lordship, to place the application before the next DLC, and it's already placed so that he gets to know the outcome of the.
No, there are, you see, we are constantly being passing orders where we have taken a view that as per the OM, Principle 10, as well as the Principle 10 of the case of Achyut Ranjan Das, you become disentitled, and now there's a judgment of the Supreme Court in Devabrata Tiwari. You be prepared and argue after the vacation. We give you time. Devabrata Tiwari. you make your submission because we have been consistently dismissing these rate petitions. 2016 is 8 years right now.
State of West Bengal, what was the word here? There are 7.5.
Both sides are represented. This is the matter of answering summer vacation. Because now the Supreme Court judgment says that even if there is a delay on part of the respondents, then also the petition is liable to be dismissed. Be prepared on that.
35.
That's good. Yeah. For petitioner.
Lordship, this is the second time the petitioner has approached this honorable court. Initially, Lordship, there was the petitioner was selected for a post of Anganwadi worker, Your Lordship. Thereafter, her candidature was withheld, Your Lordship. It was kept pending. All the other selected candidates.
So we have filed our affidavit, and one of the main things which we have said, which is also reflected in the first order, Your Lordship, where the court issued notice, is that whether the select list was extended or not, because it was the select list was of 2019, Your Lordship. And we have stated that it is not extended, Your Lordship. That is also our instruction, and we have put it in the form of an affidavit also in our affidavit in opposition. That is in page number 46, Your Lordship. Continuous page number 46. Without that, Your Lordship, possibly they will
No,
not
but
be.
there's no point you undertaking a selection process and then don't appoint.
Lordship, there was, we have given some reasons why, because there was some complaint, and they've also not made the party which has repeatedly, which has made the complaint. They've also not made the party.
In a selection of Anganwadi worker and helper, those people are not required.
No, Lordship, the reason I'm saying this is because initially they said that there was, because of the complaint, the matter was stopped, which is true, Your Lordship. Subsequently, it is their claim that complainant has taken back the complaint. That is, but without annexing any document or something, they've said that I've come to learn that this organization has taken back the complaint. So now there should not be any bar. That is what they're saying. As far as we are concerned, Your Lordship, we have stated that because of the complaint initially, we had stopped the process, Your Lordship.
No, but have you abandoned this appointment altogether?
Lordship, this has been filed by the CDPO.
No, you see, nowadays with the let us say for every time you undertake this process of advertisement, every time there will be a complaint. So for how many years you are not selecting any person? You can't stop every recruitment process just because there is a complaint by somebody.
Otherwise, Your Lordship will see that this was it was the recruitment process for almost 15 people and 8 number for Anganwadi workers, and others we have done only for this because of some complaint and all these things we could not do it at that time, Your Lordship. One of case, Your Lordship. It's not that everything is there, Your Lordship. Lordship, I have also.
But Mr. Mukherjee, if the select list is not extended, we can't do anything about it.
One submission, Your Lordship. Perhaps the submission is submission of my learned friend is misconceived. Lordship will come to page 38 once, Your Lordship.
It's 38.
38. The first time I have approached this honorable court,
Yes.
I had made the complainant and the other person a party to that writ petition. The honorable court took this writ petition at the motion stage and directed the director to do this exercise to see whether the complaint is surviving or not, and then pass an order within 2 months. I did not file a contempt against that because that person will be my superior authority. I did not file a complaint. Rather, since he was not doing anything, I filed this second writ petition, Your Lordship. In the second writ petition, in their affidavit in opposition, which is filed by the CDPO, it's a very evasive ground. Your Lordship may peruse page 49, para 14.
Yes.
Here they are saying, the CDPO is saying that as regards the statements made in para 18-19, the CDPO admits that I have approached the concerned director and also given a copy of that to the CDPO for consideration of my prayer in lights of the previous judgment of this honorable court. Then para 15, the CDPO says that I was not the CDPO at that point of time, so I have no personal knowledge whether he approached, the petitioner approached my office or not. Pursuant to this, Your Lordship, I may file an affidavit in regard if
Everything said and done. If the selection that the select list is more than a year and it's not saved,
yes, Your Lordship.
then you'll have to wait and participate in the next selection process.
Thereafter, Your Lordship, in para 17 of the affidavit, in the last portion,
Yes.
they have said the deponent also begs to state that at the present there is no initiation of a fresh appointment process. They did not say directly that that select list was extended or.
But that is something we can always take judicial notice of.
Yes.
Because the validity of a select list is 1 year.
Yes, I understand that, Your Lordship. They did not extend because this was during the time of COVID period, Your Lordship. I don't know whether the requirement of extending it by way of an order for that period will be required. And after this affidavit being filed, Your Lordship, though I have not filed an an affidavit in reply to this. When this evasive stand was taken by the CDPO, I approached the director's office again, Your Lordship, to say that the CDPO is saying that he was not the CDPO at that point of time, and it was. I have received this copy, Your Lordship, and I may, if I may be permitted, I will file it, Your Lordship. It says that CDPO was directed to inquire into the matter and report to the director within a period of 7 days, Your Lordship. That was not done, Your Lordship, in my case. In spite of the previous order by the High Court to carry on the exercise within 2 months and see whether the complaint is surviving or not, and thereafter take a decision as to whether my candidature will be there or not.
Then begin on record by way of an affidavit.
Yes, I can file an affidavit. The CDPO is saying I was not the CDPO at that point of time. Whether the record says.
No, CDPO keeps on changing. That's why.
That is the stand on affidavit. They are
Yes,
saying
yes. I'm not saying it. She's saying that I approached.
No, whoever is the CDPO, but once you have approached, and then there's an order of the director to make an inquiry, you do it.
Let him bring, I'll also get the instruction. I'll also file the affidavit in reply to that affidavit.
Bring it on record. Mr. B.G. Mukherjee, counsel for the petitioner. Placement is granted liberty to file additional affidavit to bring on record. To bring the stand of the petitioner on record. List after answering some vacation. Take back this letter.
36.
Please, Your Lordship. This petition files, my lord, against the, my lord, non-consideration of a prayer of the petitioner for, my lord, to be the, my lord, securing seniority over the, my lord, private respondent number 6 and 7, my lord. What happened, my lord, my lord, can you see page 32, my lord? In the selection process, including written test, my lord, the petitioner position was first, but she was deprived by deducting her marks in the written test. Then, my lord, she challenged the, my lord, procedure, and during the pendency of this writ petition, her mark was reassessed, and subsequently she was appointed, my lord. But, my lord, since she is the top of the, my lord, selection list, my lord, my prayer, my lord, so, my lord, I may be allowed to seniority over the, my lord, 6 and 7.
Yes, what is your stand?
My lord, seniority is claimed from the date of appointment, my lord. Seniority is given from
No,
the date of
from
appointment.
the date
my lord.
of the select list.
Select list.
It will always revert back to the date of select list.
Yes, my lord. On the other hand, my lord, they have delayed challenging this seniority, my lord. He is
No, it
appointed in
doesn't,
2015, my lord.
those things doesn't matter. You see, the petitioner has told us when he's in his submission that after re-evaluation, he scored higher.
Yes, sir.
Correct. So the scoring of higher marks was not by a separate process. It was by the same process where the respondent was 7 and 6 were also appointed. So always the appointment orders would be referable back to the select list. And that's a well settled position of law.
Yes, my lord. But
Then-
delay is, my lord. Is
Can we allow this writ petition? Notice is served on respondent number 7 and 8,
Yes, your lordship.
6 and 7.
Yes, your lordship.
But there is a judgment, my lord. B.S. Bajra for the state of Punjab, my lord. And inordinate delay may be challenging seniority, my lord.
Yes.
I will submit, my lord, later on, if you permit. my lord. Just fix after vacation. my
What
lord.
does it say?
Just say the inordinate delay may be challenging seniority list in inordinate delay may be condoned, not condoned, my lord. B.S. Bajra of the state of Punjab.
What is the date of the select list?
Select list, my lord,
2015.
Sorry, not the seniority list is dated.
seniority list, my lord,
Not
not
yet
yet published, my
Published,
lord.
my lord, seniority.
Then if the seniority list itself is not there, then where is the question of delay? And according to you, what is the delay? The chief engineer, what do you call the order is passed by the competent authority on 14/10/2022.
Yes, my lord. She was,
Files an appeal. Appellate order is 6/5/2023. And he files this writ petition on 1st February 2024.
she was appointed in 3/8/2015, my lord. That after in the earlier petition, my lord, no direction has been
So
given
tell
by
us,
the,
where is the gradation list?
no petition list is not yet published, my lord.
Then where is the delay if there is no gradation list? You don't publish a gradation list and then you say that there is a delay in challenging. How would the petitioner know where he stands without a gradation list?
I have to take instruction in this regard, whether any gradation list has
It's a
been,
question of law. You don't have to take instructions. Your department will not give you instructions on law.
whether any gradation list has been published or not. I have no idea, my lord.
You have started the argument. You said that there is no gradation list. You see, if you want to take an adjournment, take it as the first blush. After you make us hear it and then we discuss about the question of law and then you seek an adjournment, that is not permissible. Why did you spend our time, even for a moment? Why did you make us spend our time?
I'm sorry, your lordship.
Sorry, won't do. Once we spend time, we dispose of the matter.
And the impugn order, my lord, does not show that there is a delay, my lord. Only on the ground that, my lord,
You don't file an affidavit, then start an argument. Then you tell us the law, that the law is that the, what do you call it, state of Punjab. Where is that citation? Give us the citation.
Hello, B.S. Bajra for the state of Punjab, 1998.
1998,
To SCC 523.
2 SCC
523.
523. Anything else you would like to say, Ms. Niyok?
No, your lordship.
Mr. M. Islam, legal counsel for the petitioner. As well as Ms. D.S. Nyok,
Yes, sir.
learned standing counsel for
Irrigation.
Irrigation Department. The case of the petitioner is that pursuant to an advertisement dated 18/8/2023, sorry, 2013, she appeared in the selection process for filling up the post of junior assistant in the office of the superintending engineer, mechanical circle within irrigation, Tejpur. Full stop. It is projected that on 25/2/2014, the marks of the written test was pasted in the was hung in the notice board of the office of the superintending engineer, Tejpur Mechanical Circle. Full stop. In the said result sheet, the petitioner was shown to have secured first position in the written test, securing 83 marks, followed by the respondent number 6, who had secured 70 marks, and followed by respondent number 7, who had secured 64 marks. Full stop. Next para. It is projected that the result sheet was removed subsequently from the notice board, and the petitioner alleges that his answer script was re-examined and re-verified at the instance of the additional deputy commissioner, Sonitpur, Tejpur. Full stop. Thereafter, a fresh selection list was up in the notice board, whereby the respondent number 6 and 7 were selected. Full stop. The petitioner claims that she was deprived of her of her selection as the first candidate. Full stop. It is also alleged that there are error in the assessment of the marks granted to the petitioner in the written examination, and accordingly the petitioner took steps for reviewing of the marks awarded to the petitioner. Full stop. In the meanwhile, during the pendency of WPC 3904 of 2024, filed by the petitioner to assail the selection, the respondent number 6 and 7 were appointed by an order dated 8/8/2014. Full stop. In the meanwhile, on the reassessment of the marks of the petitioner, she was her name was recommended for appointment in the available vacancy. Full stop. Finally, the petitioner was appointed by an order dated 3/8/2015. Full stop. Resultantly, the previous writ petition, being WPC 3904 of 2014, was closed. Next para. the petitioner claims that as she had secured first position, relatable to the initial merit list, public result which was published, pursuant to which the respondent numbers 6 and 7 were appointed. The appointment of the petitioner would also relate back to the same select list. Where is the select list?
My lord. Page, my lord, 35, the total,
35.
Total mark sheet. Then pursuant to this, they are appointed, my lords.
First of all, in this regard, the learned counsel for the petitioner relies on what is this annexure?
My lord, annexure, page 35, annexure 4, my lord.
Relies on annexure 4 within bracket page 35 of the
Annexure
Recruitment.
5, sorry, annexure 5.
Hmm?
Okay. No, sorry, annexure, annexure 3, 3, 1, 2, 3, my lord, annexure 3, the part of annexure 3, page 35.
Also, part of annexure 3 within bracket case 35 of the Recruitment. Which is the mark sheet for interview signed by the members of the board on 25 to 2024 and 28 to 2014, sorry, 14, and 28 to 2014 respectively. With the mark sheet, the petitioner with roll number 241 is shown to have received 76 marks in the written test, 0.5 marks in the computer practical, English, 0 marks in computer practical assemblies, 1.4 marks in Viva OC, and total marks 77.9. Stop the respondent numbers.
Serial number 63, my lord. Serial number 3, roll number 63. Sudarshan Bhuya.
6 and 7. Have secured 78.3 and 78.6 respectively. Full stop. Next one, the on 11/8/2022, the petitioner submitted a representation claiming seniority, which was rejected by who's passed this 14/10/22? 14/10/22 order, which who has passed?
14, 10.
In your list of dates, you have given 14/10/22. Where is that order?
Pursuant to that mentioned in the interim order, my lord, I have written, my lord.
Don't read now, when I'm halfway dictating the order.
Well,
You are reading the brief now.
appeal against, my lord, is it appeal file against, my lord?
Your claim was rejected 14/10. Your list of dates, serial number 14. Now I'm asking you, where is that order? Mr. Islam, can we are passing the orders after vacation? Let it come after vacation. I really don't have time.
My lord, sorry, my lord.
I really don't have time. This after see, the summarization is paid for by Mr. M. Islam, counsel for the petitioner, with DS New York, then standing counsel for PHE.
Irrigation, your irrigation, your
Irrigation department is present.
Lordship will find it that order it is
14 page.
I have closed it. Mr. R. Bhutijari, standing counsel for finance department is present.
Correspondent number.
Okay.
Item 37.
Highly oblige, your lord.
Yes.
Petitioners are retired employee of corporation, my lord, that at the time of retirement, they have received the CPF only and the
Just a moment. Just a moment.
Similarly situated person, my lord, approach this honorable court, my lord, is directed to respondent to examine their claim, my lord.
No, that can't be done because you are not the employees of the government. Therefore, this pension rules will not be applicable to you.
No, I'm not seeking for pension, only CPF, gratuity and leave encashment, that is, my lord. The CPF release, only leave encashment and gratuity has not yet released, my lord. At that time, my lord, they filed representation and similarly stated person also approached, my lord. The honorable court directed, my lord, that annexure is that to examine the claim and then.
Yes, what is your stand?
Lordship, I'm appearing on behalf of Corporation Department. Corporation Department, in this matter, Corporation Department is not a necessary party. The Corporation Department is not a necessary party. So respondent number 4 may be strike off.
If you want any names to be struck off, you file an application. This warehousing corporation is not under the corporation department.
It is under cooperation department.
Notice. I have to see whether anybody is appearing.
Assam State Warehousing Corporation. Yes. Is it under the corporation department? No.
No, not my lord. It is a corporation, my lord. Under the.
No, but if it is not under this.
Assam State Warehousing Corporation is a corporation, my lord.
No, why we have implicated respondent for?
However, my lord, it is statutory body itself. However, that is under the respondent number 3 Assam State represented by the commissioner secretary, that under the, because their chairman is from the government of Assam, my lord. That the chairman is also made party here.
No. If State Warehousing Corporation, if it is under the
Warehousing Corporation.
Huh?
Yes, Assam State Warehousing Corporation is under the cooperative department, my lord. That the commissioner, who is the respondent number 2.
No, once it is not a this, you see, Assam State Warehousing Corporation is not a cooperative society.
No, my lord.
Then how it will come under the corporation department?
It is a statutory body itself. It can be sued and it can be sued, my lord. That I have also categorically made statement also, my lord. Is a statutory body, can be sued. However, my lord, that is, there is a control of the respondent.
Can't be.
Number 4. That's why, my lord.
Can't be. If it is not a cooperative society, how will it come under the corporation department?
It's not a cooperative society.
Then we strike out the name of respondent for.
Maybe strike off. Maybe strike off.
Okay. Miss
P. Bania.
P.
Bania. P.
Counsel for respondent number 4 submits that the corporation department does not have any stake in the respondent number 1, i.e. Assam State Warehousing Corporation. Stop. Accordingly, she prays that the name of respondent number 4 be struck off, being not a necessary party. Full stop. As we do not find anything on record to show that the Assam State Warehousing Corporation is a cooperative society within the meaning of Cooperative Societies Act.
I am not, my lord, I have no statement that is under cooperative society.
The
It's
the
not
respondent 4 is not is not a necessary party. So accordingly, the name of respondent 4 is struck off. Now, yes, what is the you said that there is similar order. Where is that?
My lord, that annexer E, my lord, that the relevant person is at page 60.
60.
60. Last but one paragraph.
No, but then you'll have to implement this. What is that department called now? Industries and department. What is that? Public Enterprise Department. So now you'll have to implement Industries and Public Enterprise Department.
That is not, I think, my lord, it's not connected because it's a statutory body can be sued and be sued under the name of corporation, my lord. Is a I have made categorically statement, my lord. Is a sue and be sued. In the paragraph 3, I have made a statement, my lord. Is a statutory corporation. Because they are, my lord, all the employees are suffering, the others are, my lord, that who approach, my lord, they have already get their, my lord, benefit because they, as they are not covered by pension, my lord, they only that gratuity and leave encashment, and if that is also not, my lord, receive, it's a financial concern they are suffering. That's why, my lord, they only earlier directed, my lord, to examine their claim and, my lord, on the basis of representation file and take a decision. To directed to take a decision to the respondent number 2, that is managing director, my lord. Lordship may dispose of, my lord, to not a praying for direction to release the amount, not a praying for take a decision on their due amount.
But Mr. C. Goswami can counsel for the petitioner. None it is on call for the respondent numbers 1, 2, and 3. Although the notice is duly served. Next, for the petitioners claim that their CPF, gratuity and leave encashment were not paid, although the petitioners have retired from the service by retirement notice dated 15/11/21, 5/10/2021, 15/11/2021, 17/8/2022, 6/7/2022, and 15/11/2021 respectively. Next paragraph. As there is no representation of the respondents and the claim of the petitioners towards non-payment of contributory provident fund, gratuity and leave encashment have not been denied. Court is inclined to dispose of the writ petition by directing the petitioners to submit press representation to the respondent number 2, along with a certified copy of this order, claiming describing the nature of their claim. First off, the respondent numbers 1 and 2 are directed that on receipt of the representation by the petitioners, they would examine the claim of the petitioners within a period of 8 weeks from the date of receipt of a certified copy of the order along with the representation. And if any payment, if any amount is found due and payable to the petitioners on account of CPF,
leave encashment,
gratuity and leave encashment.
and some area, my lord.
No, don't add one by one. You said 3 items first.
Yes.
You see, you've given a chart at page 7 and 8. You don't say about the area. You have given a description of only leave encashment and gratuity.
Yes, ma'am.
You see, vague claims will lead to again contempt, because you are now saying in prayer number 2, release the outstanding area pay of 2006. Now, how would somebody get that calculated?
They are clarified, my lord.
No. How would somebody clarify this 2006? Now we are in 2024.
My lord, that annexer C, my lord, they have clarified in our RTI specific amount is there. Annexer C page 38, my lord. Annexer C page 38. These are the, my lord, corporation said to us amount of so and so by name, my lord. That is why.
Oh, this is something some LDA is giving.
That will, my lord, that area, that everything will, my lord, they examine whatever we are getting. Because retail employee Assam, the name area receipt is amount iman. Annexer C onwards, my lord.
You see, we don't have any clarity. Once we start reading the papers, then something new tumbles out. Now look, you showed us which page? Page number?
Page number 38, my lord, Annexer C.
Now come to page 36. In 36, now you are writing area pay of 1996.
No, this is.
So now everything is cropping up. It's just like phoenix. From the ashes, new things are coming out.
My lord, these are claiming, and subsequently.
Please have clarity, because you see, 1996 is how many years now?
Yes, my lord.
Then?
No, I am not praying for direction before the court that has to be given. Only, my lord, that will examine them, because they are saying that these are the amount due.
You tell us. You tell us, give a statement of what do you think your amount is due. Because we don't pass vague orders.
NXRC, my lord, NXRC statement.
Vague orders
is
we
there.
will not be passing.
NXRC statement is there, my lord, I am saying. NXRC statement, my lord.
No, let it come
Para
after
7, my lord, para 7 I have stated in para 7, my lord, that the petitioner state that they file individual application under RTA information to get the information about the outstanding.
No, this certificate by an LDA. LDA is not a certificate which can be acted upon.
No, but
LDA what the document you are showing us is a certificate given by a LDA. You don't even have the document of an accounts officer. LDA doesn't make payment of salary.
In RTA application, that's it.
Then you take a risk. No vague things. I must have clarity in the order. I must understand what I am passing and then pass an order.
That LDA.
Just an LDA will give a certificate, the secretary so-and-so trust. This is 26 lakh rupees.
I am also saying it because if the authority is the managing director is not this not signing, is a LDA is a signing and giving Assam State order in view of the that then next is deputy manager. Annexer 13 and someone is given deputy manager, someone is given LDA. That's why check.
This comes from.
On the basis of that, I couldn't claim, but if there is anything new,
if the petitioners have any other claim, it would be open to the petitioners to give a detailed, to submit a fresh, detailed representation, quantifying the nature of claim, if any. Full stop. Next para. The learned counsel for the petitioner places reliance on the decision of the order dated 15/11/2021 passed by this court in WPC 5878 of 2021, wherein certain timelines were given for release of payment. Full stop. In the event the petitioners are found entitled to any payment towards their dues as indicated above, respondent authority shall also provide the timeline to the petitioners within which they would liquidate the dues of the petitioners. Next para. The petitioner is permitted to produce a certified copy of this order before the respondent number
2.
Respondent 2. To enable the said authorities to act accordingly.
38.
Other matters I will not take up. This one matter I wanted to, the outer turn, you'll have to take up.
In this matter, 2 weeks further time is required to file affidavit. I have to obtain the instruction and item 38 month.
Item 38.
My lord.
Okay, Mr. V. Kumar, counsel for the petitioner is present. Mr. UK Goswami, done at CGC. Case for is granted. How much time?
2 weeks further time is required.
2 weeks time to file affidavit in opposition in the matter. Just after ensuing vacation.
My lord, only date after vacation, any date, my lord.
We are not fixing a date because
Give your
for last about 10 days we are fixing all matters after vacation. Make a mention.
Item 41, some difficulties are there. This 38% they are not getting salary since April 23. It's a very serious for their families.
I am for respondent PL policy. I have received the instruction. I will file affidavit.
That is the marketing board will file, but the respondent number 1 and 2 they have not filed there.
Who is respondent 1 and 2?
Is important.
1 and 2 is the
Agriculture department.
Give us item 40.
41.
Okay.
And I think, my lord, we'll have to make finance department a party, we'll make them.
Yes, finance secretary party.
Who is responsible for 1 and 2?
The agriculture department,
Your Lordship, I am representing City Council Agriculture Department, Mrs. Arbor.
they should file affidavit, they cannot sit on the.
You file an affidavit.
And we'll, as I understand, my lord, we'll have to make finance department a party.
Finance is an asset.
So. we'll
You
make
are
them.
fixed pay workers.
Yes. Sir. Minimum pay, my lord, they are getting it, about 22,000 or so. But from April 23, my lord, they are not getting any cents. So their families, my lord, they are, some similarly situated person, they committed suicide.
Mr. B.D. Das, Senior Counsel, assisted by Mr. H.R. Das, Counsel for the petitioners. Next, the learned Senior Counsel for the petitioners has submitted that there is some urgency in the matter as the petitioners are deprived of their monthly salary
From April 23.
from April
23.
2023.
23.
Full stop. Mr.
NJ Gogoi.
NJ Gogoi, learned Standing Counsel for the
ASM, Assam State Register Marketing Board. ASAMB.
ASAMB. Submits that he has received instructions and will be filing an affidavit within 2 weeks.
That's it.
Full stop. The respondents in the Agriculture Department shall also ensure that their affidavit in opposition is filed by the next date of listing. You're not saying anything, you make an application.
Yes, my lord, we'll make a finance department a party.
You make an application. You're not saying anything right now.
I was
List
told
of
there is a
answering,
system of filing, making a party.
vacation.
Regarding item number 56, would
you
kindly fix the
I love this.
because I am outstation council and there is some.
No, we understand. Just a moment. We just will try to take it up. 39, item number
56.
54. Other matters will not take it up. It will be adjourned.
date may
Just
be
taking up
fixed.
these matters.
39.
It will all be rolled over. Whatever is left out will be rolled over. It goes after vacation. Yours is item number
56.
56.
Sushil Kumar.
Yes, who is for the
Mr. Munir is for the petition.
But in this matter, my lord, an amount.
yeah, just a moment. Yes.
When in this matter, my lord, an amount to the tune of rupees 26.01 lakh was overpaid to the petitioner, my lord, due to wrong fixation of pay scale, my lord. My lord, the petitioner was initially left the organization in the year 2009 and thereafter rejoined the organization as a new appointee in the year 2011, my lord. Now, as per the prevailing rules, my lord, the persons who are coming from a private sector, my lord, they are to be placed at the particular pay scale at the lowest grade. Now the pay scale was not 36,600 to 62,000. So his pay scale was supposed to be fixed at 36,600. But instead of that, the last drawn salary, which he has drawn in the year 2009, prior to leaving the organization, that was 41,000 something, that was not fixed. And in the consequence, from 2011 onward, 26.01 lakh was paid in excess. Therefore, my lord, thereafter, during a course of CAG audit, my lord, this irregularity was found, my lord. CAG report is also part of the record, my lord. And for now,
This is, you're claiming from which period to which period now?
Now, my lord, only claiming for the last 5 years, that is starting from, my lord, 2018 to 23. 18 onward, last 5 years, my lord, last 5 years. We have passed the order, my lord, for recovery in the year, my lord, 2023, January. So only for the last 5 years. Now, my lord, in the meantime, my lord, the writ petition was filed and an order of stay was passed, my lord, instructing us to recover anything. Now the employee is going to retire in this month itself, my lord. Therefore, my lord, only thing, my lord, I am beseeching right now, if your lordship, this matter takes some time to, my lord, elaborately argued, my lord. Only thing is that, my lord, his whatever superannuation benefits and other retail dues are concerned, my lord, that should be, my lord, made subject to the outcome of the writ petition. Otherwise, my lord, it is a public exchequer, my lord, which will lose, my lord, huge quantity of money. He was the AGM, my lord, at the time of joining, additional general manager. And admittedly, my lord, pay protection was available only for the government employees, and those are coming from banks and other institutes, not from private segments. And there was a gap of, my lord, 2 years before joining. So he has to be considered as a employee from the private sector who is joining. My lord, the CAG report your lordship will find in my opposition, my lord, where from the issue begins, my lord. At page 62.
What is his, what is your group of employment?
My lord.
What is your status of employment? You are group 1, 2, 3, 4, which category?
Category, man. Only 6. There are hardly 2 posts above him, my lord. He is the GFP. He is in the category of AGM, my lord. Additional General Manager.
Additional General Manager.
Yes, AGM. Now perhaps he is GM. At the moment, he is GM.
Then this,
General
whatever recovery is being made, it is subject to further orders of the court.
Ma'am?
Because the recovery sought to be made would be subject to orders of the court.
There is a order, my lord, no recovery should be.
But that is an interim order. They cannot enjoy the interim order as a final relief.
But you won't be released they will not be released, they will not be releasing the money with the extent of 5 of their claim.
I'm not getting the lordship.
No, the amount which the amount retirement dues which is due to you
Mine.
will be paid less 5 years claim which they are making.
That is
That
their
will be
claim.
subject to orders of the court.
That will be subject, obviously.
Okay. But Mr. P.K. Munid and counsel for the petitioner, Mr. Mrs. Counsel for the respondent numbers 2 and 3.
2 and 3. Arnab Chakravarti. A Chakravarti.
A Chakravarti, counsel for respondent number 2 and 3. Who's for CGC?
No, I am for 2, 3 and 4.
Yeah. Mr. K. Fukan, okay. Your name? MS N. Kalita, and counsel appearing on behalf of Mr. K. Fukan, Ms. K. Fukan, Lanet CGC. Next paragraph. Due to positive time, the matter cannot be taken up today. Next, the Lanet counsel for respondent number 2 and 3 has submitted that the petitioner would be superannuating in this month.
30th of June.
In this month, i.e. 30/6/2024. So he has submitted that the petitioner was given benefit of incorrect fixation of pay, which was detected, and thereafter the recovery process was initiated for the excess payment received made to the petitioner for the last 5 years.
From 2018 on.
From 2018 to 2023.
It was detected on 27 January 2023. That may be recorded.
Okay.
It was detected
on
Milord,
27
detected by the Milord CAG or report Milord, that is at page
The
62
order is
dated
my-
23rd of December 2022.
27th of January 2023.
And I have communicated him on January.
27 January 2023. Full stop. Accordingly, as an entry measure, and to protect the interest of the respondent number 2 and 3, it is provided that it would be permissible for the respondent numbers 2 and 3 to withhold the disbursement of the amount claimed by them while paying the retiral dues to the petitioner. First of, however, the said amount shall be subject to further orders that may be passed by this court in the matter. First of, list after ensuing.
Milord, dues will be paid, Milord, less the amount which is not claimed. Milord, that has been clarified, Milord. Perhaps.
That will be decided on the merit of
Yes.
Now, Milord, as I understand, Milord, since there may be a contempt for Milord violating the order, Milord, I want to understand that the retrial dues will be paid deducting
Less-
the amount,
less-
less the amount. Kindly,
less-
Milord, make it clear. Milord.
It is clear.
Yes.
Orders will not be waived. Yes.
Milord, would your lordship fix the matter on any day after vacation, Milord?
No, make a mention after that because we can't really fix dates now. Every matter is being adjourned for last so many days after
That I
vacation.
understand. Deeply updated.
Yeah, just a moment. Mr. Manir,
are they going to disburse the retirement benefit now?
pardon me?
Are they going to disburse?
Yes, whatever is due to you except for these 5 years.
Yes.
Only that, except for this 5 years
But
claim.
that will be outcome of the.
Outcomes. We have not said outcome, we said further orders of the.
Fine.
Except the 5 years.
Yes.
Item 43, I was in CRPF. I have been discharged from service due to some mental problem without treatment. I have then I filed this arbitration in High Court. I could send the matter back to the authority. Authority sent for medical examination. There are controversial medical examination. In such a situation, I have filed another petition that accepting this Hathiar duty, any other duty, peon, chokidar, I may be provided. So that they were asked to bring the instruction in on this regard.
Because we are already out of time, that's why.
Only on the immediately after vacation, matter will be listed.
Give it after the item number, Mr. Mavik,
43.
43. Okay, after vacation. Make a mention after that if it's not listed.
Lordship, may I please, Lordship, item number 41, your Lordship. Maybe fixed after vacation, any date, your Lordship.
No,
Suspension.
it will be rolled over. It will be fixed after vacation, but it will be rolled over. We are not fixing dates in every case. We are not fixing, passing any orders, but it will be all rolled over.
Lordship.